Yes, pass on all the memos. Please pass on. Pass on all the memos.
My lord, this matter is assigned to
Why
different.
you are mentioning different bench?
The bench which will pass the order, one of the judge will pass the order is on the bench. So it has to be assigned to different.
So that you will just go there, let them release, and thereafter it will be on an administrative side. Why you are mentioning on a judicial side? Yes, call the rules.
Test submission item number 1.
My lord, I beg your lordship's
It's a
pardon, my
very
lord.
contested hearing matter.
My lord,
Why
I beg your
the
lordship's
press
pardon.
admission? I find the last order.
My lord, I am in virtual mode making a mention, my lord. My lord,
Yes, who is appearing?
yes, my lord, I am in virtual mode making a mention, my lord. The list, my lord. Item number 34. I have some personal difficulty. I pray, my lord, let it be taken up.
Do you have any junior or a friend here?
No, my lord, today I have some personal difficulty for which I have not
Oh,
come.
you
My
may
lord.
have. Don't you have any friend or a junior here in Cuttack?
Yes, I have. I
So
said, my lord.
just request him to remind us. Don't worry.
All right. Okay.
The only difference which was taken in this in the counter affidavit by the state was they had preferred an SLP before the Supreme Court.
Yes.
Since
Notices have been issued.
Sorry, Madam?
Notices have been issued.
In this writ petition,
In the
SLP has been dismissed. Has been the end of the matter, my lord. That is the only point.
Blacklisting, I was member of that bench.
Blacklisting, yes, my lord. Your lordship was a member of that order was quashed by your lordship.
That judgment was challenged before the Supreme Court.
Yes, my lord. And they
So
did not pay any heed to the judgment of your lordship. I will just show one letter.
If I submit one line, my lords, the writ petition was amended and the prayer is also amended. To that effect, we have to file a counter affidavit, my lord, because now the tender has been cancelled and that
Twice they have taken time on this ground. Twice.
Opportunity, my lords, because the counter to that effect is not filed, my lords. Para 16.
Why? There was a direction for filing the counter.
Yes, my lord. On 8/5, as per the orders recorded, the consolidated writ petition was submitted to the state.
Yes.
Thereafter, my lords, counter has not been filed to amend effect, my lords. Whatever amendment has been carried out.
What amendment has been carried out?
Now they are challenging, my lords, the cancellation of the tender, my lords.
During
It was not
pendency of
the original
when the matter
During the
was
pendency of the appeal.
Yes, my lord.
yes, madam. The pendency of the writ petition, they cancel the tender. That has been. I have sought to challenge that.
Is a subsequent event.
Yes, madam.
Yes. That effect, my lords, counter has to be filed. With other respect, counter has already been filed in this matter, my lords.
To
My predicament
that
is this,
IA, have you filed
The IA has been allowed.
no, against that IA, whatever government he took, had you filed?
Not there.
They are entitled.
My kindly appreciate my predicament, madam.
Kindly under the CPC also.
Yes, madam.
If the plaint is amended,
Yes, madam.
then the amended plaint they have a right to file an additional written statement.
My lord, I don't deny them that right.
So that right is there.
Twice they have taken adjournment from your lordship to file a
No,
counter.
I find from the last order,
Yes, madam.
it is a 7-5, where the direction was passed upon Mr. Acharya, I think for your
Yes,
to serve the consolidated or complete copy of the writ petition by tomorrow.
yes, madam.
So nothing. On the next day, on 13th, the direction is passed to list the matter as a fresh admission.
It did not reach, madam. The matter was listed. It did not reach on that day.
So let them, how soon you can file your...
2 weeks, my lord.
My lord, just one line.
why don't you file it a shorter time?
With respect to the amendment carried out.
You can't file the counter for the rest of the amendments which were already there. Just do an amended portion, nothing more than that.
My lord, this act, my lord, I'll tell you just one line I'll submit to your lordship. This is being deliberately done Why I
Can you,
say so,
can
my
you,
lord? Why I say so, my lord?
can you defy, Mr. Mukherjee, the right to file?
It's not.
Additional?
They have, my lord, judgment was passed by your lordships here, quashing the order of blacklisting. They did not adhere to that. They carried the matter to SLP. They waited for 4-5 months. When I pushed the matter, only then the SLP defect was cured. The matter was taken up. Only notices were issued. No stay was granted. And in a subsequent tender, they disqualified me on the ground that I'm a blacklisted contractor, even after your lordship had quashed the order of blacklisting. And
That I have read.
yes, my lord. Now, my lords, what happens is, my difficulty is this, my lords. My lords, I am
That you are prevented from participating in any fresh tenders.
And my lords, not only that, I have to have a minimum amount of work done to stay on as in that bar as a super. The contract tender, this particular tender also provides that the previous year I have to have a turnover of 2,000 some lakhs to qualify to bid for the tender. Now what happens, my lords? I am not working because they have blacklisted me, they have forced me not to work. I am not having that turnover. So my future is doomed.
No, I understand. That will take care of that. Don't worry about it. But a right, you can't deny that right.
My lords, have they
10 days, you'll have to file it. Yes.
your lordship fix a date, my lord.
Since the amendment sought for, the amendment to a pleading was allowed by the court, and a direction was passed upon 7th May 2025 to serve a complete copy of the amended writ petition by 8th May 2025, the counsel for the state prays for an opportunity to file the counter affidavit thereto. Stop. The counter affidavit be filed within 10 days from date. List the matter immediately upon the expiry of the period for filing the counter affidavit. Give a date.
On 2nd July.
2nd July, it will be there.
Your lordship, any day after 7th, my lords, I have a little difficulty till 7th, personal difficulty, my lords.
9th.
So then fortnight time will give them.
Your lordship, grant them time, but let it be at the top of the board on that day. So that is my only prayer.
Yes, at the top.
Sorry, but didn't mean that. It's my anxiety of my client and
Yes.
Item number 2.
Approval of my escalation quantified by the engineer. And the assurance made it will be made within.
That I have seen escalation price.
Yes, Lord. So they have not single after the order. I have not received the one from the now 43 days. Not a single affidavit also compliant. Last order of your Lord's order dated 12th May 2025. Approved quantified 15 days.
Yes, there is already a direction.
I understand the direction only the problem which the department is having is there is no guideline frame. So the superintendent engineer has already written letter to the government to approve the escalation bill, and once it is approved from the department, then the funds will be released.
He can't wait perpetually or eternally.
I understand.
So continue. Annexure 1 is already there. There was a direction upon the superintending engineer to immediately comply. That with the very, very strong observations that failing which the action that would be just and proper will be taken up in accordance with law. How long a person would remain? You can't shove the responsibility that you have written a garment and the garment is sitting tight over the matter. So you are also an instrumental of the government.
And the only problem with the department is facing the period for which the escalation bill is asked for. For that period, there is no guideline or formula which is.
There is no. It has to be found out.
Yes, ma'am.
Normally it does not have.
Yes, ma'am.
In those kind of a contracts, there is nothing. It is because the escalation depends upon situations.
And engineer is the technical person.
And the technical persons, the resolutions are taken that how to work out this escalation. You have to take a decision.
Yeah.
What is, I do not know why guidelines is required.
Of the
This is, I understand that the approval is necessary. You have already decided. Annexure 1 is already there, that the approval has been granted. What more? Once you have taken a conscious decision, granting an approval that they are entitled to an escalation of price under the terms of the contract, then it is you to have to work out.
Amount also quantified, annexure 2 page 50.
That is what is there at the court in the earlier, the proceeding bench. I've already recorded that will have to.
The deposit within 48 hours to what's going interest. Let the deposit.
maybe last, I think last opportunity,
This is not a. This is I must be. Don't take me amiss, but this is what is a recurring feature which I find. Asking for an instructions when the matter is pending for a long time. It is not a fresh matter which has come for the first time. I can understand. This is pending for a pretty long time. Several orders have been passed. Still instructions. That is what.
Weeks time may be done.
What for?
So that the process may be completed and the payment may be released for to that effect.
2025. The the earlier bench took note of the affidavits containing the annexures, whereby and whereunder the approval was accorded for price escalation in terms of the contract entered into by and between the parties. The direction was for the past that in the event such compliance is not secured, the law will take its own course. The Council for the State submit that the Superintendent Engineer, the Rural Works Division, Kendrapara, has already approached the government for further directions in order to comply. The decision appearing from annexure 1 to the affidavit filed by him. Stop. Though the counsel for the petitioner opposes the prayer, but to give a last opportunity, let this matter be listed after fortnight. In the meantime, compliance as directed on 12/5/2025 shall be ensured. What more?
Only he has not filed any affidavit to process the
Whatever.
petition of right.
Whatever.
Yes, sir.
Let's call the next.
Item number 3.
All connected are similar.
All connected matters
Similar. All are approved.
So this is review of.
Yes, sir.
Three, madam.
May I please? This review application has been filed for within the order dated 34/25, passed in WA number 440 of 2025. May I take your lot?
I have filed this review application for reviewing the order of this honorable court passed in WA number 4740 of 25.
Yes.
May I take your lordship on the ground of error on the face of the record? May I take your lordship to page 10 of the writ appeal? Appeal has come. Page, it is very much necessary to find out the error where it has occurred. Page 10 of the writ appeal. Prayer portion I am reading. The appellant petitioner therefore prays that this honorable court may graciously be pleased to admit this writ appeal, and after hearing both the parties allow order passed by the honorable single judge dated 28/3/25 passed in IA number, this is very much important, IA number 4189 of 2025. Then being agreed also against that order also, only I was agreed. Then I am taking your lordship to page 23. That is the order which was challenged in the writ appeal. Page 23. It starts from page 22. Page 22. It starts. That is the impugned order which was challenged in the writ appeal. And my challenge was categorically in the IA application. That is in page 23. Hard. IA number 4189 of 2025. Hard. In the interim, the opposite party number 4 shall not be allowed to participate in the process of election in respect of Kotak Bar Association to be held on 29th March 2025. Then I take your lordship to the impugned order, which I have, where it is
Notice,
this is a report is to
right has accrued in favor of the other side.
One thing may I mention, my lord. Your lordship says passed in that order due to mistake on recording the order.
A order is passed dismissing your appeal.
And-
That means the person in whose favor, that is the respondent in the main appeal, and he emerged successful in getting your appeal. If we want to review that, he is entitled to be heard. He's entitled to be heard. So without hearing, can we review our order in their absence? So that's why we are directing the notice to be issued.
Heat appeal also they were not heard. Order was passed on the first.
Sir, madam, but the law is.
Why I am worried?
The law is-
Because only for 1 year, and before 15 hours the election has been cancelled.
You know the law better. You
How
know the
come
law
they-
better.
10
Still you are arguing.
the petitioner, but he has been
You know
deprived
the law
of.
better. Still you are arguing.
Yes, but why I say,
When a person-
because your lordship passed the order that the single judge will hear the matter. Case was posted to 16/4, but it has not been listened. Why is that? This is a bias.
Upon the respondents.
A woman advocate for the post of executive member, if she will suffer like this,
No.
and they are the advocates within 3 days, I am taking notice, I am serving.
Yes, notice.
They may be listed on Friday.
Within by tomorrow.
Yes.
By tomorrow. The pendency of the review applications shall not prevent the same in proceeding with the writ petition and securing the disposal thereof.
That may be fixed.
Yes, exactly. After 10 days.
Yes. Item number 4.
Lordship, here I challenge a particular provision of the Orissa Gram Panchayat Act. Challenging, in fact, Lordship, the constitutional validity of that particular provision.
Advocate General is appearing.
No, my lord.
This first time it has come, Lordship. So, AGL appeal, then it will better, Lordship, can be.
He has to be noticed. The challenge is made to the violence of section 26 of the Orissa Gram Panchayat Act. In the instant definition. It is categorically avoided the instant petition that the aforesaid provision of the said act contravenes Article 243 within bracket G of the Constitution of India, and therefore is liable to be struck down. Since the violence of the state act is challenged in the instant petition, the notice upon the London Advocate General is required to be served. Let the notice be issued upon the Advocate General. Requisites by tomorrow.
By tomorrow.
I do not know why requisites here.
I am
You can serve it straight away.
That
is what I am groomed up
Lordship.
there. Why? It will really expedite the thing.
Lordship, I'll serve extra copy, Lordship. I have soft copy and I'll.
The advocate on record of the petitioners. The advocate on record of the petitioner is directors of the petition along with the elections upon the London Advocate General in course of this week. This is matter to week. And shall find the affidavit of service on the written.
Lordship.
For our appearance here,
Yes, please.
we are also to assist your lordship since the question of law is there. We have filed an application for impeachment, that's on record.
Let him, you'll implead one word.
They let him serve us a copy also.
Must you be implemented.
Senior advocate, Lordship,
It's a question of law.
we did assistance,
This
Lordship.
is the internal matter among the.
It's a,
In fact, Lordship, senior advocate should appear to assist on law. That's why, Lordship.
He will assist.
Lordship, that's why, Lordship, we expect. Lordship.
that is why Lord, our IA is there on board.
I'll serve a copy, Lordship, let him appear and assist, Lordship.
Second.
Next week, my lord.
Next week.
25th.
Lordship, grateful, Lordship.
Item number 5. 25th.
Well, this clearly relating to public libraries in the state of Orissa.
In the state of Odisha.
Yes, the last time inspection was
Been collected, my lord, I've spoken to the department. Only the affidavit.
Local, this is a very local cause because library, if it is accessible to a common man, it means it will help.
Yes, my lord. My lord, all records have been collected. What steps have been taken are mentioned, I've mentioned in the affidavit, my lord. Some time.
Public interest litigation, so it's not a adversarial litigation.
My lord, only.
What is your stand?
Only the steps what are to be taken and what steps are to be taken and were taken.
First, you tell us that are you taking a decision to establish a library in different corners of the state?
My lords,
That is your decision that has to be taken.
some,
The modality is that how to, should it be in a physical form or should be in an electronic form? These are the things you have to take a decision.
yes, my lord. It's
Accessibility to the knowledge is always embraced. Then access you should give.
some time may be given so that I might apprise the court. What are steps are contemplated to be taken in this matter and how to bring about the changes. And
This is what we really wanted.
first, that affidavit is, my lords, will take some time, my lords. That's why, my lords, because all the information are now collated. Some time may be granted for filing, drafting and filing of the affidavit, my lords.
Last time also, the same prayer was made. So last chance may kindly be given.
You see, in November 2024. Yes, yeah. So you must have acted, must have taken some steps in this regard.
So on matter on 7.5, the order was very clear.
My lords, that's last opportunity.
This is not it.
And
Not
can't
it.
be-
Not it. There is a complacency. I do not want to say anything on that. On whose part? The order was very clear that you said that you want to collate and collect all the documents so that when you come
Yes, my
and
lords.
tell the court that what steps have been taken. And the court has also said, yes, you collect it so that you will communicate the decision with clarity and precision. The word is used.
My lords, now department has collected all the data and
That was also
only, my lords, to that effect, affidavit and drafting, 1 week time may be granted, my lords, as last opportunity.
despite the specific order passed on 7/5/2025, directing the Rahman to communicate the decision of the Rahman upon collating the several the collating the relevant documents. The accommodation is stopped on the identical ground. Certainly, counsel for the state that the government has collected all the relevant documents and the modalities for establishing the library in the different parts of this state.
My lord, actually the prayer was for proper implementation of the Odisha Public Libraries Act 2001 to appoint against the vacancies existing in all the public libraries already established. My
They have
lord.
passed
They are in
the
place.
resolution. They have passed the resolution.
Yes.
Very valid.
Yes.
There's a response.
Yes.
It is something from the council. So if a government has conducted also relevant documents and modality for establishing library in different parts of the state. So it's
Or the libraries which have already been established to streamline the launch of the same by providing the infrastructure, including the human resources. The recommendation, the submission is made to in this regard with liberty to file an affidavit disclosing this. Let such affidavit be filed within 2 weeks from date. List the matter of
On 9.
Here, the matter related to road widening, even if plan has been approved for 40 feet, but they are deviating it and they are trying to make it 100 feet, and thereby private lands has been completely
Your
deprived.
land has been taken.
So they have not taken, but they are evicting me without any notice,
They are evicting you.
evicting 500 families.
Are you within the 500 families?
We are the senior citizens and social activists, and we are right to the
The persons who are aggrieved, let them come. At least one of them should come.
because Supreme Court guidelines also fix in that Manoj Tebariwal that they have to follow this procedure before widening on.
But your locus standi is the first question.
No, because I am.
Is it a public interest litigation in that sense? I'm just asking.
Yes.
And that too at your behest.
Yes, I am also resident of that area.
Is it different? Are you going to be affected by the?
The members of this association, some of the members are affected.
Has the association come up before us?
Yes. Senior
So
citizen
under the society
registration.
registration. Are you a secretary?
I am the president and duly authorized. I have given the authorization letter also. I have been authorized to file this case. And we have ventilated the grievance before the authority. In 2016, there was a plan for widening the road to 40 feet. Now debating that without giving prior notice, which is not required, they can go to 50 feet, but they are going to 100 feet. Thereby 500
What's the
families.
widening of 200 and what you say? Is it 240 feet?
It was for 40 feet
40.
from 7 feet. And now they are making it 100 feet. And without rehabilitation, without anything, they are going to demolish our house and evict us. And Supreme Court categorical says regarding road widening, you have to follow these procedures. And you have to see that they have to be rehabilitated, they should be given notice, kind level guidelines. They have given direction to all the secretary of all the states. That in regard are 30 of that judgment. Page 8. Before acting in pursuance of a road widening project, the state or its instrumentality must ascertain the existing width of the road in terms of official record map, carry out a survey demarcation to ascertain whether there is any encroachment of the existing road with reference to the existing records maps. If any encroachment is found, issue a proper written notice to the encroachers to remove the encroachments. In the event that the notice raises an objection with regard to the validity of the notice, decide the objection by speaking order in due compliance with the principles of natural justice. If the objection rejected, furnish reasonable notice to the person against whom adverse action is proposed, and upon the failure of the person concerned the act, proceed in accordance with law to remove the encroachment unless restrained by any order of the competent authority or the court.
Yes, what is to be done? These are the modalities which have to be
Yes.
done in case of a road widening. So, are there encroachers or you wanted to overreach their land? Then the Supreme Court has also said that you'll have to acquire the land.
Yes.
And it's,
Correct.
what is forthcoming from the record is a notice for,
Any proceeding is initiated?
to that effect, I have to take instructions.
The Supreme Court has said that that has to be brought to its logical end by passing a speaking order.
Yes.
My lords, if I may suggest one thing, my lords, is these grievances can be put forth before the competent authority and the representation will be considered by the competent authority. All these points which the petitioners are there.
The first and foremost thing according to this judgment is that you will have to just make a survey. That when you want to widen the road, then you will have to make a survey by engaging an army. He will go and find out that how far this widening would go. And if it is found that some encroachers are there in those lands, then the second, the initiatives that have to be done, whether those are all the government lands and they are the encroachers, or it is a private land. If it is a government land, then you give a notice. Initiative proceeding for the encroachment cases or whatever. I do not know here what is that. So this is to be done. And order removed. If you want to transgress over their land, which is their own land, then it have to acquire an acquisition. Every case. Very, very sorted state of affairs. In every case.
What is the difficulties that on the first occasion it is difficult for us to obtain instruction from the department members.
Because they are has
Some short time so that what will. And
prejudice the citizens.
it's an understanding.
To frustrate them. is how much they
2 weeks, my lords.
take it so for the
Not to proceed further with the construction and the eviction, because they are evicting us. Not to proceed further.
there is your allegation.
Force eviction in all the paragraphs.
Your prayer is only for impose that whether they will go for 100 feet or not. This is all the government.
Yes,
prerogative.
procedure they have to follow.
How can you restrict that? No, don't go for 100 feet. Go for 50 feet only. And you can't.
It is not required. I am saying so.
Why so?
Let them survey.
Why
Let there
you
be a
to say-
survey. Let there be a survey. Without survey, nothing they are going to do that.
What is the interim order you have asked for?
Status quo.
Very dangerous order.
Not to proceed further with the on this road widening work without
The proceedings of eviction. Then you are citing a judgment of the Supreme Court.
no,
It goes against you.
no, your lordship, status quo may be maintained.
The action of the government in widening the road without following the statutory provisions applicable in this regard. It is a word in the incident in the incident petition that while widening the road, the government has transgressed upon the private land owned by the inhabitants of the said locality without adhering to the provision of law. It is further pleaded that the action of the government is contrary to the law. The Supreme Court in Manoj Tibrewal Akas reported in 2024 INSC 863, wherein the 3-judge bench unequivocally laid down the law relating to a road widening project. It is held that before the government embarks its journey on widening the road, must ascertain not only the existing width of the road on the basis of the official records, but must also carry out a survey / demarcation in order to ascertain whether there is any encroachment on the existing road with reference to the official records. it is further highlighted that in the event the encroachment is found on the government land, it is imperative on the part of the government to issue notice upon such encroachers and initiate the proceedings. To stop. Stop. The aforesaid proceedings must be decided expeditiously after giving an opportunity of hearing and by passing the speaking order. In the event the land owned by the individual is required for the purpose of widening the road, the appropriate acquisition proceeding is required to be initiated. And a reasonable compensation so determined should be extended to those persons. According to the petitioner, neither any survey is conducted nor any notice is issued contemplating the encroachment case to be initiated against the individuals, but the government officials are banking upon completing the project of road widening, and there is an immediate threat of their disposition from the respective land. The Council for the State submits that in absence of any express instructions in this regard, she is not in a position to apprise the court of the real state of affairs. Be that as it may, in view of the decision rendered in Manoj within bracket Supra, unless the steps required to be taken by the government is undertaken, it is not open for the government to take the law in its hand and proceed for the widening of the road by departing the settled proposition of law, by departing the proposition of we therefore pass an interim order.
Alex, with respect to interim orders, with respect to interim order,
We pass an interim order to the effect that in the event any encroachment is found after complying the mandatory directions passed in the above reported judgment. What's the interim order? And a proceeding is initiated. The eviction cannot be secure unless a final order is passed in such proceeding after affording an opportunity of hearing to the respective encroachments, if there be any.
If I may only submit one line, my lord. My lords, if my lord permits me, then 1 week may be granted. I'll apprise the court what is the situation. My lord,
What's the purpose of an interim order? The concept of an interim order is ingrained in the statutory book.
My lord, it install
The
a public
purpose
purpose,
is
my lords.
that if there is an immediate threat, it has to be protected. The civil right or the constitutional right of an individual is required.
My lord, two things in the petition, my lord, they have not.
You are not in a position in absence of any categorical instructions.
My lord, from the writ petition, my lord, they have not averred that if any private land has been acquired.
We have not recorded that.
My lord, and
We have
second,
not recorded. We simply say that if there is an encroachment found, you have to initiate a proceeding and then you can evict otherwise.
my lord, a public notice has already been issued, which is appended.
It is not. Is it a law that once the public notice is issued, no proceeding is to be initiated and the person would be thrown out of their position?
Only with.
So,
Yes, my lord. My lord, the only submission is if any proceedings have been initiated.
so that is, they have said, that's why you brought it, pass it order, throw them out. That is what we said. Without that, you come. Is the matter after 2 weeks? Is you want 2 weeks?
My lord, 1 week, my lord.
One. Not required. 1 week. Let us go. Somebody review order that has struck us.
Item number 7.
Yes, one of the petitioners grievance against opposite party number 4, who has enforced the
Who is
plan.
the opposite party number 4?
Opposite party number 4 is one Supreme Court letter, who has enforced and unauthorizedly constructed
Yes.
house and poultry
He is a
farm.
whistleblower, madam. Your land is enclosed. Everyone. Yes, what your instruction? No,
My lord, 2 weeks number.
I don't have that they have also submitted a representation before the collector manager to consider the same. Yes.
and we direct the representation to be made, then we will, that won't be heard personally. It will be opposite party number 4 who will be heard.
Well, that of minister.
You will not be heard. Take instruction, come after 2 weeks.
Item number 8.
Minor mineral concession rule mines. Once was allowed to reach out in my favor for 5 years. By this is page 26, start from page 26 by annex of 2 months.
This is the lease agreement.
Lease agreement. By
The
Tahsildar,
duration is of 5 years,
5 years,
commencing from
2022 minus,
2000.
22 months. That is there,
So it is valid till 27.
27.
Okay.
But the problem is not there, minors. The thing is that minors Tahsildar kind of got to pay 34 minors. Tahsil, it was a lease deed executed between Tahsildar and the petitioner, the petitioner, who were the highest bidder. Thereafter, what happened?
34, why you are taking us?
Taking minutes, the lesser is the Tahsildar last option.
That's true, so on behalf of the government.
Government, on behalf of the government.
Right.
That was then minors under the revenue department. All the soilers were dealt with under the revenue department of the government of Orissa. Subsequently, by virtue of a notification,
Now the mining officer has become,
the mine
not the Tehsildar.
yeah, or the
So will it invalidate automatically the lease?
there manner the street pinches. Kind of a glass to the things that Tahsildar required me to return all the wild farms miners. I returned it. Then Tahsildar has given all these papers to mining officer who immediately act upon that kind of annex 5.
When that act came into force, that amendment.
To amendment came, that not amendment, that notification minors in on 6/1/2023.
22, effective from 2023, my lord.
So this was prior to.
Yes.
Prior to
I
that,
just wanted to know.
yes, sir. Then kind of glass to annex 6. page 53, the Tahsildar has given all these particulars, including record to the mining officer. Last two documents, approved mine planning and Y-firm.
Then
All that Y-firm I returned to him. That could not operate because the Y-firm was not there with me. Then what happened? Then very important is thereafter.
why you cannot operate? I just wanted.
But fact remains, my lords, if that something things have happened thereafter. How can you answer, sir? Annex 7, the mines officer must require me to submit another modified mine planning. First, there is a mine planning. Happen, one leased it out through auction process. Thereafter, now when this has been transferred to the mining officer require me to submit another mining plan, revised mining planning. In absence of mining planning, I cannot enter into that spot miners because this is the first step. After compliance, Tahsildar has done it. Tahsildar, just before that, Tahsildar also enclosed that approved mining planning. In spite of that, they required a mining planning to be submitted. That also I complied. And then I complied. Then no answer, nothing. No operating order is being given. Now I am waiting whether the mining planning is being approved or not because the miners coordination. They said that coordination is being.
There is a four coordination.
Four coordination. Miners knows that.
To have a boundary.
Suppose miners XY coordination in one side differs, then miners I would be in trouble. They will say that if I am unauthorized, I have taken miners query, decide us.
When the Tahsildar has already annexed the site map or a site plan. The
Mining
question is that where it will end, these are the boundaries, is butted and bounded by this. Why the mining officer requires some.
Refer to page number 55, Annex 7. It is mentioned that during the inspection, it was found that the coordinates of so-and-so query mismatched with the mining plan. Hence, a new mining plan was asked for, my lords. But my lords, issue here is not that, my lords. Issue here is, my lords, thereafter demand notices were issued and a show cause proceeding notice was also issued. And thereafter, personal hearing opportunity is also called for on 16/2. Now, my lords, the learned senior is challenging, impugning those demand notices as well as.
He says not a demand, he wanted that where is what has happened to a plant. My plant.
That is the
Never said
subject.
so.
My lords, as per the prayer, my lords, the challenge is not that, my lords.
Then you have to communicate a decision that what you have taken regarding this
Yes.
device plan.
On my lords, let me refer to page number 67, my lords. Annex 14.
That is a subsequent development, but I'll come to later on. The thing is that their miners I could not operate in view of the miners the requirement. I submitted a mining planning spending miners 40,000 rupees as they required that. That is not being approved. They are days for the subsequent years.
But they have not put the stoppage notice. They have not put.
Miners, right, miners?
They have not
They
put the
have
stoppage
not.
notice.
Miners, right.
If they have not, then you could continue with that.
Well,
So that it,
it
does not mismatch.
I'm sure management will appreciate it. If the coordination of the particular spot is being disputed, entering into that mine area miners is a disputed one. I cannot take it up.
It is.
I cannot take it up.
It is not.
Well, kindly see miners last line.
That there appears to be a mismatch in that.
No, the mismatch is there. They could have said it. Last line miners that answer 7. What they said? The rectifier showed that the source can be operated smoothly. So you have to see that mining planning should be given. If you are going to change the mining planning or I am violating the mining planning, it is the relevant time where they have right to rectify it. Unless and until it is rectified, I cannot enter into that. Now the dispute is that the mining planning is given by Tahsildar. You require a revised mining planning of Archaeological.
What it says that the mining plan means the mining plan,
Yes.
which was annexed to the lease.
Yes. No, that is not that. With reference to
that the coordinates of the
yes,
Pagoda sand quarry
yes,
are mismatched with the mining means what you are claiming that this is what has been given.
Yes.
It says that
so that requires a demand.
that means you might have
crossed over.
That may be a contingency.
So this your
That may be a contingency also.
Confined within that mining plan.
That may be a contingency also. Then might it require a survey, my lords. There both parties should be there. You have to identify that because Tahsildar on identification given that mining planning. May I submit my? May I place my part, my lord? May I place my part, my lord?
Will But at page 30, the entire description of the land has been given so clearly. I do not think that.
I'm clarifying. I think I might appreciate better.
Of the land.
I will appreciate better. Yes.
What it says.
Yes, but this is the area given.
Right. And then it says that it is butted and bounded.
Yes.
By on the north by this
South,
east, west.
four corners.
No difficulty.
No difficulty.
And the GPS
They have
also been given.
They have the Tahsildar has
Coordinates have been given.
Must kind of visualize one. Once this is
to prevent you from operating.
must can visualize one thing. The thing is that must what is going on the field and what is there in the record. Tahsildar is to give me identify the spot after mining planning paper lease deed executed. Accordingly, I operated. Now, when this is being transferred to the mining officer, they are disputing that you are not allowing the coordination.
No, they say that the coordinates are mismatched.
Yes.
They do not. What is the coordinates? When the latitude and the longitude does not, that appears to be. But when the land was already given clear position by giving a boundary, then in that event, then
may I submit my lord? Latitude and longitude concerning in the x and y axis, my lord, I am conscious of that position. But fact remains, now the does not match means I am operating either beyond or not beyond. But the thing is that now you require a specified mining planning to be given.
No, sir, you find your response.
They said you submit another coordinate mining planning. I submitted that. Either you accept it and say that yes, this is the coordinate mining planning which is confirmed, then I will go ahead. But once you require that the coordination of the mining planning and it will be prepared by the competent officer, authorized officer, those who are capable to paying 40,000 rupees and has submitted it before you, then you could have verified and said that you go ahead with that modified mining planning. But in absence of mining planning, as per the rule 28, I cannot go a step forward.
The description of the land comprised in the same lease is also appended in part 1 of the said lease deed. On behalf of the government of Orissa, Tahsildar as an authorized officer executed as it means deed, but by virtue of a subsequent event, the power that are mismatched. So, the mining officer requisitioned the register to file a revised plan, which in fact has been done. Revised and modified is a two
Synonyms.
It counts
Two
to.
synonyms.
So, but me,
Modified and revised. This is two synonyms.
yeah, absolutely. That only my humble submission is, so far as the my
Modified.
modification of money.
I am accustomed with the word.
But
by,
sometimes,
which is
used by
another state.
the way minors place the matter, I also that minors conscious with position and
Modification. Defined. Subsequently, a proceeding is eviction, which has not culminated into a final decision. According to the senior counsel appearing for the officer, once the modified plan as requisitioned by the mining officer was submitted, it should not be kept in a suspended animation for all times. The mining officer must indicate whether this modified plan has been or not. It is thus submitted that the mining officer must be directed to communicate the receipt of the said modified classes. The counsel for the state vehemently opposes the submission of the senior counsel appearing for the prisoner in contending that was it and a demand was raised upon the prisoner, and therefore it is too late in a day to contend that there is no discrepancy. They contend that the prisoner has not defaulted in depositing the royalty and other charges applicable. She have a place for a direction to file affidavit to disclose all the relevant documents. Considering the nature of the disputes and taking into account the communication made by the mining officer and its compliance by the prisoner, we feel that the state must file an affidavit disclosing all the relevant facts in this report. And since the proceeding initiative by the competent authority is still pending, we do not think that the same should be staged or stopped during the pendency of the instant repetition. Accordingly, let this repetition be listed. After 2 weeks, the counter affidavit shall be filed immediately.
Now they are insisting for payment of these areas that they claim that say subsequent years.
Initiation is there.
Minutes.
Take that.
No, we have submitted that so to the reply and stated all those. We have stated all.
Item 9.
Item 9, my lord. Also, a nature of the my lord, where the opposite party force complaint.
The interim application में लाए, the interim petition might fight an interim में लाए,
Okay.
लाए होगा मेरा, so it will consider after filing.
You have done, don't worry.
The
9.
opposite party for is the executive officer of Chaudhar municipality have allowed over plot number 29 and ward number 19 to construct Anganwadi center, which is complete deviation of the report submitted by Archaeological Survey of India. If you will see page number 8, that is 18. That area is completely protected, my lord. Yes, madam. Page number 18. Annexure 1, madam. It is clearly mentioned that over plot number. May I read out?
Now, the Archaeological Survey of India, I think there is the law which is applicable says that within a particular area vicinity, there should not be any construction activities if particular structure
Yes.
is of a historical value and the Archaeological Survey of India has taken over.
If that should remain vacant, but the
If construction has already come up, then no further construction shall be allowed.
no.
Demolition is not there.
No, what information that is the Anganwadi center has not yet been constructed, but the work order has been issued. If your lordship see page number.
Madam, if it falls within that particular area, there is an Archaeological Survey India Act is also there.
Yes, ma'am.
It talks about a certain restrictions
Yes, page.
within a particular peripheral of the archaeological site.
Yes.
And if I may refer to only page number 29, there's Procedural municipal.
Page number
29, my lord.
yes. It has shifted to a school site.
Now, in that side, the Anganwadi center, the government proposes to build an Anganwadi center.
But whether it is in complete compliance with the mandate of the ask
That is no NOC have been obtained.
from the Archaeological Survey of India, you have to obtain it.
Yes, I can take instructions to that effect, but formalities have been carried out.
Well, apart from that,
Now it is at the level stage of the work order. Now the construction has not ensued.
not ensured. Well,
So it has not ensued, started.
yes, ma'am.
So you come with the instructions.
Yes, but what?
And look at the app.
Yes.
Have you got the Archaeological Survey with the India Act? You got that?
Right, I have, no, I don't have, but madam, one line I need to submit, madam. That is what instruction we have got that the agreement is also executed
But this is
every time the construction may be taken.
construction. paperwork will maybe done, but if they start the construction, then
Yes, that is the predicament.
so that they have not started as yet.
But anytime it should be
Yeah,
started.
if they start, come, do not. You should come ready when you are filing a PIL. You should be very much ready
Yes,
with all the provisions of the Act and the rules.
I'm sorry.
See it.
The Union of Archaeological, this, you mentioned a party.
Oh my.
Have you seen those acts?
Yes, my lord. Section 19 talks about
No,
protected.
section 20, subsection C, which is subsequently amended by 2010 Act. By virtue of this act, madam, there are two things which was brought. One is the identification of a prohibited area, and there is an identification of a regulated area. Prohibited area, complete embargo. Regulated area, you have to make an application and seek permission from the competent authority, means there is a director of the archaeology department or the higher rank officer. Subsection 2 of section 20C says any person who owns or possesses any building or structure or land, here is the case of a land, in any regulated area and desires to carry out any construction or reconstruction or even repair or renovation of such building or structure on such land, as the case may be, may make an application to the competent authority for construction or reconstruction, repair or renovation, as the case may be. So without the permission, you can't. And that is their grievance. And it says that so far as the prohibited area is concerned, section 20 capital A, which was introduced in 2010, every area beginning at the limit of the protected area or protected monument, as the case may be, and extending to a distance of 100 meters in all directions, shall be. So within 100 meters, you can't, peripheral. And the regulated area is 200 meters, section 20 capital B. It says that every area beginning at the limit of the prohibited area in respect of every ancient monument and archaeological sites and lineage declared as of a national importance under section 3, extending to a distance of 200 meters in all directions, shall be a regulated area. So if it falls within the prohibited or
As per this notification, it mentions protected area, my lords. The reference which is made in annexure 1, it refers to protected area.
it's not a protected, we have to say it's a prohibited or regulated. Protected area is not that. Protected means it comes within the prohibited, no construction.
Then I'll take instructions to that effect, my lord.
Let's till this status quo may be granted.
What status to matter? No. We did dangerous order. I will be beseeching you to read the judgment of the Supreme Court in Kishore Khaitan. If I am not wrong, it is a 2006 volume 4 SSC. Where the Supreme Court deprecated passing of the status quo order.
Then your lordship may fix a sorted.
A serious question is raised in the Minister of Public Interest Division on the decision of the government to construct an unavoidable within the vicinity of an archaeological site without taking any permission and or approval from the competent authority as defined under the Ancient Monuments and the Archaeological Sites and Remains Act 1958 as amended from time to time. It is a specific of the register that the site at which the proposal to construct a HON'BLE center is approved by the government comes within the restricted area contemplated under the aforesaid act, and without obtaining and the requisite permission and or approval from the authority, no can be made there. The Council for the State submits the recommendation to take an appropriate steps in the proposed HON'BLE center is required to be constructed, comes within the ambit of the act as relied upon by the petitioner. Let this matter be listed on after 2 weeks, just to give a time. In the meantime, the instructions shall be received by the Council for the State.
Okay.
19. Till now, the security deposit and the final bill of the petition has not been paid. The lordship may kindly annexure 7, page 49. That is your completion certificate issued by the executive.
Why you are not paying the money? He has executed the work and completed. You have to make an inspection and
Only one preliminary objection, my lords. Petition, my lords, in a purely civil dispute, because the claim is with respect to.
APL International.
My lords, then, my lords,
APL International Limited judgment of the Supreme Court.
my lords, if I may refer to my lords, then State of Kerala State Electricity Board versus Korean K. Kalati, wherein it has been held that the interpretation and
Here,
my lords, the citation is my lords 2006 SCC 29.
thereafter the APL has come.
Still, my lords, in a purely
Of a
commercial,
three-cut bench, it says,
it's purely commercial dispute, contractual dispute, my lords.
permissible.
Proper remedy might be
Permissible.
suitable. Yes, my-
Is a larger bench, this is. The Supreme Court has said, yes, in a contractual matter, there is no difficulty Article 226 can be invoked, even for recovery of money can be done.
Then to that effect, my
By
lords.
justice as we said now. Find out that EPL International. Development. You found out?
Well, it's just opening and it's.
Is the leading case.
Real infrastructure.
EPL International. And followed consistently up to 2025.
Well, it's still, there is still set of judgment which talks about when
But
purely
that is a
commercial.
larger bench, then when if it is a larger bench, this is it. Here is the judge, three judge bench, this is it. When the two judge bench differ,
You can take instructions. My lord.
if there are two judge bench, Supreme Court and a three judge bench, which will prevail on the High Court? The three judge, so. Give them money.
I'll take instruction, my lords.
Weeks time instruction.
Item 11.
11 becomes transport fee transport fee और मुआवजा जो yesterday losses. Not the problem.
Item 12.
But 12 is restricting to allow the 180 ml
Oh,
liquor.
yes.
Item number 13.
13 lakhs. This case, what has happened? On 19/3/2025, there was a tender for sanitation work in Bhuban MSC. I participated in the tender, and on 23/4/2025, in the technical summary report, my bid was rejected on this ground that I had poor performance. they rejected my tender. I challenged that in a writ petition, that writ petition number 11351 of 2025. The day I filed the writ petition and that matter was listed, the same day they were a notice and late night millets, they issued a corrigendum which is under Annex 12. They cancelled that tender. Because I challenged that the ground of poor performance was never a part of the tender called notice.
They have cancelled the entire bid.
They have cancelled the entire bid.
So they have to float a queue.
They have floated. They have floated a new tender millets that is under Annex 14. That on 14 5 millets.
So participate there.
I have participated. What has happened, millets? In that tender millets, they have inculcated this poor performance as a condition. That is what I am challenging, millets. Because in the previous tender millets, what has happened? Only I was the person who was rejected on the sole ground. State.
Who is the parent?
Your Lordship, we have not received a copy, and it is against the MSC Bhuban, so they have a separate counsel to mention.
We have served the copy, millets.
MSC Bhuban notice has to go.
Notice has to go, millets.
Any final?
Yes.
Millets, may
Yes.
MSC.
Millets, may I pray?
When they are going
In the year 2014, 15, 16, only a part of the road, that is only 256 meters, was not completed because there was an encroachment. And by order of this Honorable Court, the encroachment was recently removed in the month of April. Now, you also imagine only 5 kilometer stretch of road, only that part has not yet been completed, and we have
has been removed in the month of April.
Man.
So if a road cannot be built in a day, how can you expect 5 kilometers?
No, because
So let them get something and start.
yes, my lord. I have no issues with that, my lord, because you will also imagine one, my lord, gate of there was a level cross, there was a train line.
So have you removed all the encroaches?
Your Lordship, that is what is from this to seek instructions, Your Lordship. Because the contempt proceeding was dropped on the removal of the.
I have given that, my lord, that affidavit I have given at page 30. They have encroachment was removed and road was handed over to the, my lord, Rural Development Division, my lord.
The public interest litigation is taken out by the alleging the apathetic and dormant attitude of the government in not completing the completing the construction of the road is spanning over various plots of land. Grams Sarak Yojana. It transpires in the course of the hearing that a portion of the road was in the occupation of encroachers, and the proceeding was initiated against them by the government, which invited the spate of litigation before this one. Ultimately, the encroachments have been removed in the month of April 2025. Yet the construction has not commenced as of now. So, since the encroachment has been removed in the recent time, the Council for the State submits that she should take an instructions whether whether the construction has ensued after the encroachers have been removed from the encroached land. So this is the matter after 2 weeks to enable the Council for the State to take an applicant's instruction.
Item 15.
Lordship, this is mentions the illegal action of the opposite parties tendering authority in acceptance of the bid of OP4 and OP5. Your Lordships may kindly have the tender notice, which is at page 50. 515.
51. Lordships at serial number 1, Lordships will see the present work.
So this was invited for
Construction and infrastructure development with different market yards. The serial number 1, your lordship.
market yards of the
Junagadh block under
Junagadh
RMC
block.
under
So
Lordships, may then kindly have page 19, Lordships. The checklist of documents which the bidders are required to submit in the present tender. 74. What the OP4 and OP5, what they have submitted in the present bid. They are the qualified bidder as on date, your lordship.
yes,
Lordships at page,
so this is the balance sheet profit and loss account
Lordships,
you have submitted.
Lordships. But there is no
for the year 23-24.
23-24. But the beneath the lordship, there is no UD. First of all, there is no UD.
UDIN number.
In the balance sheet for the financial year 23-24, there is no UD. And then if your lordships may have page 80. The balance sheet for the FY 22-23. Your lordships at the beneath will find that there is no date, no signature, and no UD.
Yes, where is the condition for reflection of a UDIN?
Lordships, it is there in the Income Tax Act, your lordships.
That is a different.
Lordship, but
That is a different one. But for the purpose of this, the technical bit, if it is not required, how can you impose some conditions? Whether it is a manufactured one, it is not a manufactured, it is up to them. They would definitely call for.
Lordship, if it is, when the requirement of the tender is that you have to submit the audited balance sheet.
That's the audited balance sheet they have. The auditors must have given his report.
Lordship, that has also not been provided.
Where it has to be.
No, your lordship, it has not been provided.
No. It has to be.
Lordship, the one note has been provided, which is at page 88. Again, that is
what is a profit and loss statement. That is a balance sheet they wanted to give, and then the audited balance sheets they have already given.
Lordship, but in audited balance sheet too, it has to be signed and it has to be have a unit to be considered.
It has to be signed by a chartered accountant.
Lordship, as for the company, because the OP number 4 is the company, and it has to be signed by the directors of the company, your lordship.
Liquid balance sheet.
Lordship.
It is by a chartered accountant.
Lordship.
Auditor who has done the audit.
Lordship, and it is mandatory after 2021 that the UD has to be there, your lordships, in each and every audited balance sheet.
So that is a requirement under the income tax, but that does not mean that in the tender bid, if they do not put any conditions at the time of a tender, you cannot impose something. If you say it is a fake one, they have not actually submitted, they will make a verification. If it is not, then
Lordship, then because the balance sheet for 2022 and 2023, which is at page 80, there is no signature to what I presume that it may be
for you to say so. If they find that they have not annexed these balance sheets, if they are the company under the Companies Act, then under the Registrar of Companies, they have to file
the. What happens is that after being like by providing a manufactured document, they will go.
Where is a manufactured document? Where is the evidence that manufactured? Have you found out from the Registrar of Companies? There's the website is, I think, the Corporate Affairs. Have you found that they have or not? If it is a company, is a private limited or limited company?
It's a private.
They are bound under the Companies Act to upload at the interval of 3 months or 6 months. That's a mandate. So have you checked from that side?
In that case, your lordship,
The
I'll
Ministry of
have to take
Corporate
instructions
Affairs,
and I'll file an
that side is
additional
there.
affidavit to that effect.
You
Lordship,
can't make out a case in this way.
lordship may further have this page 113.
Yes.
Look, there are two grounds. First is that the balance sheets are not proper, and second is that the lease agreement which they have submitted for the plant and machinery, they are not as per the Indian Stamp Act and as per the transfer of property.
Now, it's a immobile property or it is a movable property?
Movable property.
So does it require a registration under section 17 of the Registration Act?
Lordships, because
Does it require? Tell us.
Lordships, because the lease deed has been executed for a period of 3 years.
There is a gulf of difference between a lease in respect of a immobile property and a lease in respect of a movable property. If it is an immobile property fetching more than 100 rupees value under the Transfer of Property Act, it is required done by a bilateral document. And in view of section 17 of the Registration Act, it is a compulsorily registrable document.
Lordship,
If it is a movable property, show us that section 17 lies.
Lordship, may have page 40 to answer to your Lordship's query. The monthly rate has been specified in.
Now, again, there is a gray area that some movable properties are also included as a immobile property, provided they are fastened to the earth, embedded to the earth in view of general clauses.
Lordship, we are.
So machineries, if they are not embedded or fastened to the earth, you can't treat them as a immobile property.
No, Lordship, these are movable property.
So does it require a registration?
Lordship, because it is more than 3 years.
Does it require a bilateral document?
Lordship,
Show us from the Transfer of Property Act. Show us.
I'll take the instruction.
We are talking about a lease. Show us that leases are coming under the Transfer of Property Act. Show us that it requires. Oh,
Lordship, I'll take instruction in this one. And I'll file the appropriate balance sheet also, which the OP number 4 has filed.
Sir, this balance sheet has done. If it is an audited balance sheets, the auditor has already certified it. That's enough. Whether it is a manufactured one or it's a fake one, this is up to them. They will ask. You have not produced any document that this is what the balance sheet they uploaded in the official website of the Corporate Affairs Ministry, but this you have not been able to make out any case. If they have taken a particular movable property on lease, it's enough.
Lordship, in the case your Lordship has a query that whether they have submitted the exact same document.
We will enlighten you or make you more wise. It is you, is your baby. You have to make out. You have to nurture it. Why you expect the base to react?
Lordship, in that case, Lordship may grant me some time. I'll file an additional.
Because the difficult questions are put. Mere averment will not do. You have to substantiate with this. Otherwise.
No, Lordship, what has happened is that they have submitted a document which is undated.
It is up to them. It is up to them. Whether they will accept, they may later on call. And also on the private.
Lordship. Lordship, the sub-collector Dharmgad chairman, who is the tendering authority, OP number 3, he has been made as a party.
That question answer one. That question answer one. We are questioning answer one.
Lordship. No, annexure 2 and 3. The tender was invited by Lordship. Both the technical and the financial evaluations. Yes. Even on this, let them. Okay, sure. That's right.
Yes, you should.
Item 16. Item number 16.
You cover case already.
Award case.
No, Lordship, it's. You cover case. I give you the other. The Lordship. It's. It's a case of a Lordship, interest has been charged, interest and penalty. The tax has been adjusted in the, on account of
Now, amendment has come. I think,
I know that 21 like
amendment here, GST council
Ah.
taken.
last of
Thereafter, statute was amended, saying that electronic credit ledger is confirmed. Adjust this.
This is covered case.
Tax payments can be adjusted with electronic credit ledger and cash ledger also.
Yes, yes.
So previously you are having cash ledger. Yes. Now credit ledger can be used. So both of these things.
Actually, with regard to penalty, that invoke the section 70 book. That is section 73 of the.
You know what he says. Check what remains, sir. You handed over to me the wrong judgment. So I was really trying to figure out what is passing through.
Sorry.
I was taken aback. What conversation is going on? I could not find a single reflection from that order. Yes, now in the meeting of the GST councils, now this amendment has been brought to section 15. So if that is permissible, can you still bank upon?
One thing I have to say, if this tax has been paid for filing of return and all, it is a demand, it has been created. So I have to verify that the demand will be allowed by input tax credit ledger. It will be adjusted.
What is the demand?
Is a demand relating to interest or a penalty or a demand relating to a actual amount of tax?
The tax has been paid. Yeah, the demand is made on interest and penalty.
The section 50. So interest. Whether by virtue of this amendment this can be taken a credit is the issue. You go through this judgment. You have not gone through this judgment. Go. Give him a copy.
Yes.
That is there.
Party agreed to pay the 73 section. Yes, madam. I understand the condition. I understand that like credit ledger can be replaced. Now after this amendment, yes, that is
What remains? Unnecessarily keeping the matter, so dispose of in the light of this. Just call the next.
Item 25.
same matter.
25 also same matter.
Same matter.
Yes. Same treatment.
Have you gone through the brief?
Yes.
Have you checked out?
Yes.
Only the section 15, subsection 3.
Yes, demand and interest. Tax position.
In with respect of ITC claim erroneous number adjusted against electronic credit ledger.
Yes.
You are disallowed. That is the issue here.
Yes.
Or not?
Yes.
Then the same fate. Yes. Give the memo of appearance.
OPS with he appears both from the.
I am
26. 26 is
Item-
appearing.
26.
74.
Yes, same service tax matters at
74. Honorable Supreme Court
Yes, sir.
retained us
Yes.
from proceeding further.
I have already checked and signed it. I have selected one.
You are appearing.
Yes, sir. I am happy. I have already corrected my name also.
You are appearing.
Happy one. Same matter. I will consider like
27, who is appearing?
27.
27 and for the petitioner, that is regarding GST arts.
Both the matters.
One is against state, one is against.
Corrected copies. Corrected copies.
Yes, Malab.
28.
28.
73. Similar.
Similar. Cancellation.
73 for me.
29.
He has not been started.
Yes, I'm afraid of the Yes, the force of the bill.
Government course of the day. Matter will appear in the next page. 30.
Item 30.
This is also similar.
31, sir.
One entry is a single matter.
31.
Both the matters, 1 and 3. 31, both the three matters are same?
No, yes.
1 and 2, 1 and 3, sorry.
Past item
And what about 2?
and absence of JC criteria.
Yes, yes. Which one? 15408.
Yes.
154.
You have written the numbers.
Please give the WC number.
Otherwise,
32.
32
From 32.
non-constitutional of appellate tribunal. I have given the correct.
Yes.
Yes.
Give.
Item 30.
30.
33.
33 is also.
Same, math.
Let us come, we start from 24. Yes.
Item 34.
Morning, I was give an adjournment because of some difficulty. And so
Judgment passed by the Honorable Single Judge by the Annex 1 is subject matter of challenge. Here the
No limitation.
no limitation already condoned. That is, delay has been condoned.
Get away.
that's the last date you all asked.
Last date before vacation, you will achieve condoned and before resignations.
What is the matter about?
But here the respondents, they were initially undergone training for gardener. Now, after completion of the training, they were not given any appointment. They were only discharged from the after completion of the training. And because of the austerity measure imposed by the finance department, no appointment was given. Then subsequently, on surrendering 71 number of regular sanctioned vacant posts, new contractual posts were created, against which they were given appointment, and subsequently they claimed the regularization against those posts. Now, by virtue of the judgment, impugned judgment, their prayer for regularization has been allowed. Now, the plea taken before the Honorable Single Judge that since they were sponsored by the employment exchange, so there was no requirement of any formal recruitment process. They have come through a valid selection process.
Yes. No.
But that is what the submissions were made before the Honorable Single Judge. And that has been accepted by the Honorable Court, and the petition has been allowed. Now, if I'll
for contractual appointments, there was some advertisement.
contractual appointments, no advertisement. Against only
So
this.
how are they selected?
They were selected only to undergo training for gardenership. That is by virtue of a 1998, that is by virtue of a guideline. They were sponsored by the employment exchange. They underwent training 10 months.
That means by advertisement you called for persons from sponsorship.
Sponsorship only for training, not for any appointment. And the guideline prescribed that will not create or give them any right to claim appointment in future. That guideline, I'll start with that guideline, my lord. That guideline is that is annexed to the counter affidavit. The lordship, that is that page.
Well, Lordship, we'll have a glance to page 59 is the counter affidavit, and that is at page.
No, I'm looking at page 43. That is annexure 2. Annexure 2 is the guideline.
Annexure 2 is the guideline. Page 43. If your Lordship would look at page 42 first. Page 42 is the communication of that guideline. Here, if your Lordship will look at the subject of that letter, selection of candidates for gardener's training. For that purpose, this guideline was framed. It has been decided to take up pre-service gardener's training in School of Horticulture, Khurda during the year 1998-99. A set of guidelines indicating selection procedure is enclosed herewith. You are therefore requested to select the required number of candidates as per the allotment of the candidates earmarked for your range. Please please state that the selection procedure is adopted meticulously without deviation and selection is completed within time stipulated therein. Now, if your Lordship will look at that guideline, the very next page, may before the clause. Page 44, Roman 8. The candidates are required to furnish a bond in the prescribed form to the effect that after successful completion of training, they shall serve under the department for at least 3 years, if required, failing which the stipend paid during the training period shall become refundable. No guarantee can be given in the matter of employment after successful completion of
which clause?
Page 44, Roman 8. Roman 8. May I place it once again?
No. Yes.
Now, these petitioners, those who are the present respondents, they successfully underwent that training. They completed 10 months of training. And thereafter, if your Lordship will find at page 48, an austerity measure was imposed by the finance department for recruitment to Group C, Group D posts. Other things, this austerity measure was imposed. So that is why no appointment was given to these petitioners, or they could not be observed or given appointment in any post. My lord. Then, my lord, page annexure 5, page 55, if your Lordship will kindly see, 71 number of contractual posts of gardener were created by the government. Now, against these posts, the petitioners were 61 number of persons, including these petitioners. They were given appointment. But if your Lordship will look at the creation of that post, I am directed to convey that the sanction of governor for creation of 71 number of contractual post of gardener, a consolidated remuneration is so and so in lieu of 71 number of sanctioned post of gardener abolished by this department.
So you converted the sanction post into contractual post.
Yes, those 71 numbers of posts were because of the austerity measure. No appointment was given against the sanctioned post.
Have they challenged this?
No, nobody has questioned this. Nobody has challenged this. On the contrary, basing on these creation of post, these petitioners were given appointment subsequently after creation on contractual basis.
This decision is valid till 28 to 2011.
Yes. 2011. Yes.
Thereafter you went on engaging.
Yes. Yes, they have been engaged for some work.
Continued with the.
Yes. Yes.
And the what? Was it extended?
Yes, still that they are.
Was it renewed from time to time?
Still that they are.
Yes, was it renewed from time to time?
It has been renewed, my lord, but that
Under
specific.
what authority?
Post or abolish?
Yes.
It was not you converted
No,
to,
it was not abolished.
in lieu.
Only thing is that
Sanction
only
post or
contractual
converted.
appointment would be made to that second post.
Sanction post or
No,
converted.
my lord, on abolition of the sanctioned vacant post,
Where is the abolished? Show us.
that your
Oh,
lord,
yes.
Annexure
Abolished.
5.
Abolished by this 19 by.
Yes, my lord.
Yes, that is abolished.
Abolition
Post was
of
abolished.
and contractual posts were created.
Yes. To contractual. And that contractual creation of posts. That is valid up to 2011.
11.
Though you were appointed by 2011. Have you stopped after 2011?
No, man.
So
But they have, if they have continued on contractual basis, they have accepted that condition and offered their candidature for the training.
what the single bench held?
The single bench, your lordship may kindly see. Lordship may kindly have a glance to page 38. Page 38,
Yes.
where the Honorable Court has taken note of that counter affidavit. The only valid ground that has been taken in the counter affidavit of the OP number 2 to deny the claim of the petitioner is that the petitioners were not recruited through an open advertisement. However, while saying so, in the counter affidavit, the opposite parties have not denied the petitioners were appointed by the District Employment Exchange. The petitioners were sponsored by the District Employment Exchange. As such, it cannot altogether be denied that the selection and recruitment was not fair and transparent. Moreover, the petitioners, along with others, were sent to training and they successfully completed the training. 23. It also appears from the rejoinder affidavit that the same practice was being adopted by the opposite parties since 81, 82 to 98, 99.
When the recent judgment of the Supreme Court delivered by Justice Vikram
Jago.
Jago.
Yes.
Justice Vikramnath delivered judgment in case of Sripal, where
No,
they have taken
Jago.
note of Jago.
No, Jago judgment has been delivered by Justice Vikram.
Yes, that was followed.
Sakai wala.
Paragraph 13 or 14.
Yes.
Of the judgment. And 14.
Seen that judgment, my lord. But if your lordship will look at the judgment of Uma Devi,
This is a different.
Yes.
That was considered here.
Yes.
yes,
In paragraph 53 and 54 of the Uma Devi, you will be relying.
Yes.
but 53 only with respect to that
Irregular appointees.
irregular appointees, long continuance for 10 years without
Without
intervention of any
order of the court.
But whether any long continuance against a post does confer
That
any
is what
legitimate
Jaco
expectation.
talks about differently. That's why I said paragraph 13 and 14 read.
But if your lordship will,
In Jaco, the Supreme Court has taken note of that. And Umadevi was considered. Suppose, then what is the law? Suppose the judgment of a constitution bench is taken into consideration by a subsequent bench
yes,
of a 2-judge or a 3-judge, whatever, and then interpreted the judgment. Let us go to the extreme case that the interpretation does it not bind the High Court? I am just asking.
but High Court is bound by both the judgments
No.
of
No.
the Constitutional bench as well as the subsequent bench.
Please consider. At least I think I could not make myself more clear. There is a constitution-based decision also. And there is a 2-judge or a 3-judge based decision. Yes. If the latter judgment of 2-judge or a 3-judge did not notice the constitution-based decision, then in that event, the High Court is bound by the constitution-based decision and will not consider the 2 or 3-judge bench decision. It is par incu. Not. Suppose a latter judgment, latter bench, considered the constitution-based decision, taking into account that, and then interpreted that what the constitution bench has actually held. Even if the High Court thinks that that interpretation is not correct, can it go beyond that, contrary to it, or will be bound by that interpretation?
Because they have not taken note of 21.
I not here although
So in Jaco, actually, the Supreme Court took into account the Umadevi's case,
but
considered, and then in paragraph 13 and 14.
But the specific findings of the observations and the position of law laid down in Umadevi has not been taken care of in the subsequent judgments.
What are you talking about?
That is what I am trying to impress upon my.
If you come in a Jaco,
Yes.
in paragraph A, the Roman 4 compliance with the Umadevi guidelines. So Umadevi was taken care of by the apex court.
But they have taken care of para 53 of the judgment of this
It has
Umadevi.
taken care of, not paragraph, they have not quoted it. Then in paragraph 13, that paragraph 12, rather I should start, and it says, despite being labeled as a part-time workers, the applicant perform these essential tasks on a daily and continuous basis over extensive periods, ranging from over a decade to nearly 2 decades. This engagement was not sporadic or a temporary in nature. Instead, it was recurrent, regular, and akin to our responsibilities typically associated with the sanctioned post. Moreover, the respondents did not engage any other personnel for these tasks. This is also a case here. During the applicant's tenure, underscoring the indispensable nature of their work. Then paragraph 13 is important. The claim by the respondent that these were not a regular post lacks merit. You are saying the post is abolished.
These are not regular posts and they were appointed against any sanctioned vacant post.
It lacks merit. Now it says that the contention that it is not a regular post lacks merit, as the nature of the work performed by the applicant was perennial and fundamental to the functioning of the officers. The recurring nature of these duties necessitates their classification as a regular post, irrespective of how their initial engagement were labeled, maybe contractual, part-time or whatever. It is also noteworthy that subsequent outsourcing of these same tasks to private agencies after the applicant's termination demonstrates the inherent need for these services. You have not terminated them. This act of outsourcing, which effectively replaced one set of workers with another, further underscores that the work in question was neither temporary nor occasional. Then 14, the abrupt termination of the applicant service
following dismissal of their original application before the tribunal was arbitrary and devoid of any justification. The termination letters issued without prior notice or explanation violates the fundamental principles of natural justice. It is settled principle of law that even contractual employees are entitled to a fair hearing before any adverse action is taken against them, particularly when their services record are unblemished. In this case, the applicants were not given an opportunity for this. And this is what the court held, that it is perennial in nature, akin to a discharge of duties attributable to a regular post. Here, there was a regular sanction post. You abolished by one stroke of pen and converted that regular post into a contractual post. So, the necessity of the work which they are supposed to discharge was indispensable. It was indispensable.
May I answer that? The posts were abolished and contractual posts were created. But by virtue of the training they have undergone in terms of the 98 guideline, that never conferred them any right to claim appointment either against a regular post or a contractual postman.
You are actually lopsided. You are stuck at one place. Forget about what is that. Let us proceed on that basis that their training in the horticulture department does not confer any right of an appointment.
Yes.
Let us accept.
Yes.
The clause relating to their training also contemplates that it is not a guarantee to a job. But the fact which you are not really taking into consideration is that later on you have employed them. Yes. As a contractual. Let us proceed.
But without any.
By
Yes.
Contractual. Let us without nothing.
Yes.
As a contractual. You have not said anything. You have said you are appointed as a contractual. How? Upon publishing these sanctioned posts, maybe on the ground of austerity or maybe on the ground of necessity. We are not going into. But there was a sanctioned post. Yes, which you abolished in one stroke of pen and converted it into a contractual post. Yes. Now, these contractual employees, if were engaged for a particular period, but such engagement continued uninterruptedly, and they discharged the duties which was initially assigned to a sanctioned post, and they still continue to discharge their duties attributable to that sanctioned post. Then this judgment says that the nature of the work is a determinant factor. If they have discharged the duties of a regular post continuously, then you cannot later on say that I will not regular.
Then your lordship may kindly have a glance to para 45 of the Umadivijan. Para 45 for a moment, man. Para 45.
Which one?
My lord, may kindly.
अच्छी चलो अच्छी
Last news. That is to.
that contractual posts were created with the concurrence of the finance department.
Other outfits were also taken note of. At para 9, you see, para
Yes.
9.
Yes, I've seen that one.
Similar lines of arguments which you are advanced normally. The same arguments are before arguments again.
Only I'll just draw my lord's attention to para 45 of Uma division. para 45. And
Let us see the paragraph 45 talks about what you are interpreting.
yes, your lordship.
Then come to Jaggo paragraph 20.
But I'll
Come to Jaggo paragraph 20. If the Supreme Court has interpreted Umadevi in this way, can we interpret in a different way? Then read paragraph 20 of the judgment.
It is well established that the decision in Umadevi does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointments, circumvent constitutional requirements. However, where the appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on their basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In recent judgment of Binod Kumar,
So this was the interpretation
given by the
to a
Supreme Court.
judgment of a Umadevi.
Yes.
Can we say that this interpretation of the court, the Supreme Court, is wrong?
But I'm not saying, my lords, that my lords will observe that Umadevi judgment is wrong or Jago judgment is wrong. If your lordship will look at para 45 of the Umadevi's judgment for a moment, only para 45.
We accept your contention.
Yeah.
I'm again that's asking you. Probably you are not understanding.
I understand, my lord.
Once the bench of the Supreme Court took notice of a constitution means the Umadevi, and then says that what the Umadevi has said or what has been decided, can we take a note that this paragraph was unnoticed by the Supreme Court in a later decision, did not understand the correct meaning of that, did not notice this? Can we say as a High Court, I'm just asking you this, Article 141, whether that can be diluted to that extent?
Then, my lords, my only answer would be both the judgments are binding so far as Article 141 is concerned, and one of the larger bench. So
that's the whole difficulty. That is the what we do not want to make any observation on that. Once it has come, what can be done?
I can only pray.
To argue, he is standing on his legs to argue on your question.
It's
only my lords can interpret that. I can only have
the court. Who was the tools? You ask that how we can interpret it. We are ready.
Then your lordship will keep it to some other day. I will come prepared with the on precedence. I'll have to argue on that.
You will not find.
At least I can make an effort that I find some judgment so that I can improve. But I have gone through this judgment, both the judgments.
Respondent has argued nature of engagement, absence of sanction,
yes,
non-compliance of Umadevi, educational qualifications, outsourcing as legislative policy decision, no fundamental right to regulation. These are the basic points which you agitate now. The same thing the lordships have taken up.
But my lord, the Supreme Court, in case of Vibhuti Shankar Pandey, Managing Director Ajmer Vidyut Vitran Nigam Limited, in both the cases, they have held in absence of post-declaration cabinet. These are also the judgments of the Supreme.
No, when?
But that is 2022, volume 19, SCC 664, and the other of 2023
of 2024,
and all of them, all of the cases, Umadevi has been interpreted either way, man.
It has been
in all the cases
in many judgments. What to be done?
And para 45, 46, 47 of Umadevi judgment makes it amply clear. If your lordship will look at para 45.
Whether your department has accepted 6 years or more service as contractual basis, that you have set a mark 6 years. If we take your policy, rules 2013 and resolution 2013 for regularization matters. 2013 rules you have brought up C and D.
Yes, yes.
And resolution also on the same day, those who were already engaged.
Engaged.
So those two, that resolution and rules, if you take into consideration, 6 years mark you have set
Yes.
for consideration. It is 10 years.
But subject
For
to,
you it is 6 years.
but subject to fulfilling certain conditions prescribed in those resolutions and notifications, my lord.
That's why I asked you that question. Once you have brought up that letter that is valid up to 2000 resolution, that is valid up to 2011, beyond that, how could you? And finance department, of course, has released funds. Otherwise,
Yes.
the accounting authority would not have
Yes.
paid them money. So
Sanction of the finance department is required because
that's
of the rules of business.
That's
10
right.
10 is a requirement.
So
Without,
finance department with the eyes open has supported this.
but my lord, accepting everything, my lord, whether any right is conferred for regularization, that is the most important point which is to be considered. Even they have been allowed to continue, they have not been exploited. Here is a case where they have their services has been utilized with proper remuneration. It is not that, and with their eyes open, they have accepted that.
Remuneration, are you satisfied?
Then I anticipated when you are drawing your attention to paragraph 25 of the JAPO. Everything was considered. What you are arguing was argued.
But my lord, only
What-
paragraph
what it says-
45 of the
what it
Umadevi
says
judgment,
is-
I'll just place
I'm
my
telling
lord,
you,
then I'll leave it to my lords.
The answer to your argument is reflected in paragraph 25.
My lord,
It is a disconcerting reality that the temporary employees, particularly in the government institution, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or regional needs, seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. Then the Supreme Court has said, first, misuse of temporary labels. Employees engaged for work that is essential, recurring, and integral to a functioning of the institution are often labeled as temporary or contractual, even when their roles may be regular employees. Such misclassification deprives workers of a dignity, security, and benefits that regular employees are entitled to despite performing identical tasks. Arbitrary termination. Temporary employees are frequently dismissed without cause or a notice, as seen in the present case. This practice undermines the principle of natural justice and subjects workers to a state of constant insecurity regardless of the quality or the duration of the service. Lack of career progression. Temporary employees even often find themselves excluded from opportunities for skill development, promotion, or incremental pay raises. They remain stagnant in their role because you have fixed the remuneration, creating a systematic disparity between them and their regular counterparts despite their contributions being equally significant. Using outsourcing as a shield. Institutions increasingly resort to outsourcing roles performed by temporary employees, effectively replacing one set of exploited employee workers with another. The practice not only perpetuates exploitation, but also demonstrates a deliberate efforts to offer regular appointments or employment, denial of basic rights and benefits. Temporary employees are often denied fundamental benefits such as pension, provident fund, health insurance, and paid leave, even when their tenure spans decades. This lack of social security subjects them and their families to undue hardship. especially in case of illness, retirement, or unforeseen circumstances. This was the consideration by the Supreme Court. What more?
Your Lordship, para 45 and 47 of the Umadevi judgment, if I fail, I fail. I need not. So, Lordship, will kindly have a glance to para.
You are stuck to this.
But
You
that,
don't want to travel beyond it.
no.
You place 45 and 47.
45 and 47. So, Lordship will kindly have. 45. While directing that appointments, temporary or casual, be regularized or made permanent, the courts are swayed by the fact that person concerned has worked for some time and in some cases for a considerable length of time. It is not as if the person who accepts an engagement, either temporary or casual in nature, is not aware of the nature of his employment. He accepts the employment with open eyes. It may be true that he is not in a position to bargain, not at arm's length, since he might have been searching for some employment so as to eke out his livelihood and accepts whatever he gets. But on the ground alone, it would not be appropriate to jettison the constitutional scheme of the appointment and to take the view that the person who was temporarily or casually got employed should be directed to be continued permanently by creating another mode of public employment which is not permissible. If the court were to void a contractual employment of this nature on the ground that the parties were not having equal bargaining power, that too would not enable the court to grant any relief to that employee. A total embargo on such casual or temporary employment is not possible. Even the exigencies of the administration, and if imposed, would only mean that some people who at least get contractually or casually would not be getting even that employment when securing of such employment bring at least some shocker to them. After all, innumerable citizens of our vast country are in search of employment, and one is not compelled to accept a casual or a temporary employment if one is not inclined to go in for such an employment. It is in that context that one has to proceed on the basis that the employment, knowing the nature of it and the consequences flowing from it. In other words, even while accepting the employment, the person concerned knows the nature of his employment. It is not an appointment to a post in the real sense of the term. The claim acquired by him in the post in which he is temporarily employed or the interest in that post cannot be considered to be of such a magnitude as to enable the giving up of procedure established for making regular appointments to be available to the posts in service of the state. Then I'll take your lordship to para 47. When, just reiterate, when a person enters a temporary employment or gets engagement as a contractual or a casual worker, and engagement is not based on a proper selection as recognized by the relevant rules or procedure, he is aware of the consequences of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post when an appointment to the post could be made only by following the procedure for selection and in cases concerned in consultation with Public Service Commission as the case may be, wherever it is required.
But by the time you engage them, this judgment was there in your knowledge. That also you have to take note of. Notwithstanding this, which you are facing now, you are conscious of that and engaged. And that austerity measure did not perennially exist. You have come down.
We have come down, but we have continued with the contractual post, madam.
But you are not coming forward with any document showing that that was extended to Then thereafter, after 2011.
Leave it to bylaws.
Again, guys, if the apex court has interpreted what actually Uma Devi decides, can we take a departure?
Mahadevi has decided in both ways, madam. Para 53 and para 45, 47, your lordship have seen that. And now, I'll just leave it to my lords then.
So he has said that what can be done after this judgment. And had it not a case of unnoticing the Mahadevi, the position is different.
I argue that it is per incurium, but per incurium cannot be declared by this court, but by the Honorable
Per
Supreme Court.
incurium is how? Per incurium is unnoticing the earlier judgment which has cited a particular point. Then secondly, the relevant statute has not been taken into considerations. Binding precedents have been overruled.
Here, the judgment has been taken
The
note of.
judgment of the coordinate bench is not taken into account. There are multiple factors which can render a judgment, but
Here, the judgment has been
Yeah,
taken note of.
that's why I
but
say
that
take note of it and interpret it.
But those particular
What can be
paragraphs
done?
have not been dealt
Then-
with in the
then-
subsequent judgments, my lord.
Then we can't say that it can be said to be a per incurium. You can't say it's per incurium.
But in case of this Vibhuti Shankar Pandey, these are all subsequent to Mahadevi.
And
Yes.
judgments, I do not know. I just wanted to know this. Vinod Kumar judgment relied upon by the Jaggo.
Yes.
And you have is also of 2024.
I don't have that judgment, but I have gone through
Vinod.
that is also this in the same. And here, my lord,
Can you show me that Vinod judgment?
that Vinod Kumar.
Vinod Kumar versus Union of India.
Yes.
Ilmo Devi, if your lordship remember, Ilmo Devi has also taken into consideration Uma Devi and passed.
Which one?
Ilmo Devi.
No.
That is seasonal. Seasonal. Not contractual.
Here also Mahadevi has been taken note of.
No, I understand.
Justice M.R. Shah's judgment. Ilmo Devi.
Part-time.
Part-time.
Part-
That is a case of part-time, but they have.
So here it is not part-time. It's
Yes.
contract.
No, Lord, here the posts were regular posts were abolished, and with the concurrence of the finance department, it were created.
It is not.
And my lord, your lordship may kindly see my annexure 1 to my writ petition. The appellant number 2 himself has written a letter to the secretary that allow me and give me the power to formally issue the regularization order, because entire appointment has been done illegally, following the ORV Act, everything. That is what, and secondly, my lord, there is a notification of the Labor and Employment Department where says that they can adopt either of the one method. One, either they can insert or they will get it from open market. And another thing, in the guideline, my lord, there is a selection test of 100 marks that we have undergone.
I asked that question because
We have undergone that test.
it's not. I asked whether they have challenged this or not. The difficulty is that there is a judgment of the Supreme Court as well as the Calcutta High Court is that the regulations or the rules for consideration of the candidates for appointment only from a sponsorship of the employment exchange is per se unconstitutional.
But here there is a
It offends Article 14 and 16. Article 14 and 16 of the Constitution of India. It has been held in S. Rao's judgment of the Supreme Court. It says that everything has to be.
But they have-
restricting the appointment or a zone of question from the sponsored candidate. This was held to be an unconstitutional.
But they
I
have
did not utter because nobody has made out a case like this.
yes. And my lord, they have
You can't
No,
say so boldly.
no, I'm not saying.
Since you are a sponsored
No, no, no,
candidate,
no, no, no.
so
You have a infinite right of appointment.
I'm not,
Impossible.
no, I'm not saying that, but because
Beyond imagination.
I am relying on their own circular.
And Annexure 7, page
Whatever,
58.
whatever, sir.
Page 58
That
is
is-
the observation
they are-
of the finance
They are
department,
not-
if your lordship.
This case was not taken up. Whatever the appointment has been made from a sponsored, the sponsorship of this employment exchange, you have taken them into an employment. Still continuing with their
Well,
employment.
they were taken
Till
from
date,
the,
you are not terminated.
well,
their
they were
employment.
taken from the employment exchange only for the purpose of training. So far as appointment is
And how
concerned,
you have given an appointment? How?
no, my lord.
Then how you gave them an appointment and how you are continuing with their appointment?
But that is why your lordship may kindly see page 58, what the finance has observed when their cases were recommended. Or if your lordship may kindly see page
No,
58.
they will say that Uma Devi is a contractual, does not really create any right, because there was a clear stipulation in the notification that they cannot claim any right of a regular employee.
Yes.
Then
And
Sipal
no
case-
advertisement, no selection
Sipal-
process is
And
followed.
you are continuing with that.
Sipal case which referred to Jago, Sipal case is outsourcing. That also you, their lordships have said. Scavengers, this sweepers.
Leave it to finance.
Now I will dictate to the chief.
Well, I have given a short note with the events.
What?
In this case for your,
What short?
in this case, from my side, I have given, I'm giving it. The date chart, list of
It's
dates.
a list of dates.
Yes, list of dates.
Only I can pray, my lord, my submissions may be taken care.
Obviously, to be tested some other avenue. Don't worry.
Even in Doctor's case, if it's pending before the honorable should,
That is only admitted.
no, the lordships I think asked you to give the data. How many persons are left out for regularization?
And my lord, the judgments of Ilmo Devi, Vibhuti Shankar Pandey and Managing Director
Same issue.
No, it's an
Same issue.
No, it's a issue is similar, but the matter is pending for the unknown signature. But only manner the interim application manner was not taken up and no order was passed. Though some protection was given manner, but that's why I have approached. So I know that manner lead appeal may not be possible maintained against the interim order. You can actually look at the order, page 67.
So the protection is given, no recovery if it is already paid to the petitioner.
No, but it's a question. My claim was annexure 14 may not be given.
Where is your prayer in the IA?
Well, in the IA
It's
manner, you can also.
IA 5230.
Yes, sir. That is manner.
Page 60.
Page 63.
64. 62. Page 62.
Tag the restriction.
Yes,
We tag the
yes. 62.
Your interim order was not to disengage
No, but
without leave.
that is manner 5230. That IA. Two IAs are there. One is 5230. There the prayer was. Lordship may explicitly please to direct
Where is this order dated 25/3/2025?
Annexure 14 to the
Page 60.
Page
660.
60.
Yes, sir.
Page 43 to the repetition.
It's a refixation of your salary.
Well, if you also look at page 37, my lord.
No, page 60,
Well,
5/3/2025.
yes,
You said that
they have reduced my salary.
salary of the
No, I was given
it was withdrawn.
I was given a regular salary. I was given a regular salary, and that was my lord reduced to 9,300 per month.
That is what I'm saying.
If you also look at page 37 per minute. Not page 37. That's a notification of University Matter 13/11/2019.
30s.
What's 37? The petition.
Well,
What is the date?
it is 13/11/2019.
13/11/2000.
19.
Yes, well. So here it is.
Page 37. In pursuance of notification of GA Department dated 12/9/70 of GN Public Department.
It has been refixed from 9,300 to 22,400.
Yes. Yes.
Subsequently.
And thereafter, my lord, page 31.
30. Next page.
30. Next page, my lord.
Yes.
It was further enhanced to 24,780 with effect on 13/11/2020. And my lord, earlier I approached this Honorable Court, my lord. The direction was that you file a representation for regularization. That is, my lord, page 51, my lord. The order starts at page 50, annexure 10. Liberty was given to you, my lord, to file a representation seeking regularization. Then, my lord, I filed an application in annexure 11. And my lord, everything, that Jacob, Birpal, everything, Sirpal and everything was.
We are not an issue. At this stage, it is not an issue.
That's correct. Thereafter, my lord, this annexure 12 and 13 was issued. 12 and 14. Page 4.
57.
Annexure 12, my lord, page 57, 17/3/25.
Yes.
Regulation was rejected, page 58, last paragraph.
No difficulty.
Well,
Yes. That is not a subject matter here, or maybe
No,
it's in the writ petition.
I
That will be decided.
that's good. But since annexure 14 was passed, 25/3/2025, I filed the present writ application along with the prayer, my lord, not to act upon annexure 14 till only, my lord, in that annexure 14 last line, and the excess payment made to him shall be recovered. That was protection was given to the petitioner, my lord, to that extent. And my selection was a proper selection.
Should be that. 17th March 2025 is challenged in the writ petition?
Yes.
Yes. Sir. Who is appearing?
University.
Who is appearing for the Berapur University? Oh, and can you do it?
the appointment is conditional. We also thanks for a moment.
You, sir, since more than a decade, you have enhanced that particular remuneration from 9,300 to 2,000, then 24, 5,000 or 28,000. You have enhanced. As the moment the representation was rejected or their claim for regularization was rejected, immediately by one stroke of pen, you said that his salary would be reduced to 9,300.
My humble solution is that since the appointment is conditional, that once a regular engineer is appointed, then the petitioner.
I can understand as far as the regular employment is concerned. He is not entitled to be regularized. Let us proceed on that basis. But once you enhance the remuneration, a contractual remuneration, how can you withdraw with one stroke of pen? You have enhanced.
The original office order of the appointment was that you also may kindly have a glance at the page 25, only one line. This is taking into this page 25, the order has been passed. In exercise of the powers conferred under section 21(1) of the Orissa Universities Act 1989, the Vice Chancellor, on the recommendations of the selection committee, has been pleased to appoint Sri Utpal Kumar Acharya, Babaji,
Junior engineer
at the rate of 9,300.
Please, probably again, that's my misfortune that I am not being able to convey what is passing in my mind. I am not on that what is the nature of their appointment. We are not concerned. Because that is a subject matter of writ. The writ court will decide it. The single bench will decide whether he should be regularized or he should remain as a contractor. We are not concerned. Our concern is that the contractual remuneration which was initially fixed, after a passage of time, was enhanced by you. Twice, not once. Twice, you enhanced it. So far as the remuneration part is concerned, we are stuck. Whether you can enhance it, you cannot enhance it, is a matter to be decided in the writ. But since he was getting that remuneration on the basis of a conscious decision of the university, can the university, one stroke of pen, reduce that immediately and withdraw? Is he not entitled to an interim protection?
Interim protection has been granted only
for recovery, but so far as the remuneration of 9,300, he is relegated.
No, that has been paid, but the enhancement part is.
Can you withdraw after paying more than a decade? Can you by one stroke? Because the representation was considered by one authority who made certain observations, which was not a subject matter before him. The subject matter was whether their appointment is to be regularized or not. What remuneration is extended, what should not be extended was beyond his the domain.
May I explain? The position is that, my lord, my lord. Authority. Only the recommendation is to made by the university, and once the state has declined his regulation, so we are not in a position.
We are probably again I am saying we are not taking into consideration any point of regularization. That will be decided by a single bench. We are concerned with the interim order. And he says that suddenly you slapped him, then no, from to 28,000 you go to 9,000. How? When he's paid 28,000 for a pretty long time, continuously by you. And that too on the basis of that observation made by the authority while disposing of the representation. When the representation was restricted to a regularization appointment, not restricted to the payment of remuneration. How?
He should have confined to the regularization, saying, no, your appointment is contractual. Remuneration. Is it? Again, that observation of Supreme Court. Exploitation. No, sir. He is entitled. You continue paying him without prejudice to your rights. That is, that entry order has to be. No. Though the interim protection is extended to the appellant by the single judge, but the challenge is made that the same is not appropriate and impliedly and the denial of an appropriate interim order implied. Admittedly, the appellant was appointed as a judicial on a contractual basis at a remuneration of rupees 9,300. Stop. After discharging the duties for a considerable period, the said remuneration was enhanced from 9,300 to 22,480 per month on the basis of an office order dated 13th November 2019, issued by the Bahrampur University. Subsequently, the said remuneration was further enhanced to rupees 24,230 with effect from 13th 780.
Yes.
780. With effect from 13th November 2020 on the basis of an office order dated 30th July 2021. Being continued to receive the remuneration at the enhanced rate, the appellant approaches the authority for regularization of his contractor as the duties which the appellant discharge is of perennial nature, akin to the duties of a regular sanctioned post. The authorities did not consider the prayer made by the petitioner for regularization, which led the petitioner to approach this court under Article 226 of the Constitution of India. The writ petition was disposed of with the direction upon the concerned authority to dispose of the representation within a time-bound manner, in a time-bound manner. Undeniably, the representation was considered by the authority, and the reasons were assigned, which disentitled the petitioner to have his services regularized. The challenge is made to the said decision by filing the writ petition and by filing the writ petition. Stop. The writ petition is still pending, as no final decision has been taken thereupon. An interim application was taken out in the said writ petition as the authority, after disposal of the representation, issued the office order withdrawing the enhancement given to the petitioner. Office order dated 25th March 2025. And relegating the petitioner to the initial remuneration fixed at the time of his engagement as a contractual employee. The single bench passed an interim order to the effect that the university is prevented from realizing and or recovering the amount paid to the petitioner, but did not pass an order protecting the remuneration paid to the petitioner for a considerable period of time on the basis of the diverse office orders issued by the university. Stop. The representation, which is a subject matter of challenge in the writ petition. No, sorry, the order disposing of the representation, which is the subject matter of the challenge in the writ petition, was restricted to a regularization of the contractual service, and and there was no whisper with regard to the remuneration fixed by the university and paid to the petitioner from time to time on the basis of the office orders. Relegating to a initial remuneration which was fixed at the time of the engagement would cause an undue hardship on the petitioner, and therefore the single bench ought to have taken into account while passing the interim order. Furthermore, the office order dated 25/3/2025, prima facie, appears to have been the outcome of the observations made in the order disposing of the writ petition, which was beyond the scope of the dispute so raised. No, dispute not, claims so raised, and therefore the court ought to have protected the remuneration which is paid to the petitioner since several years. We therefore dispose of the instant appeal by passing an interim order restraining the university. No, sorry, interim order that the university is restrained from implementing the office order dated 25/3/2025 until the disposal of the IA. Stop. The payment of the remuneration at the enhanced rate shall be without prejudice to the rights and contentions of the respective parties. And in the event the single bench is invited to decide the aforesaid issue, the same is subject to the ultimate decision that would be taken in the said writ petition. Disposal, no cost.
Item number 36.
P6. In response to our objection filed that I have sent it to the department for their views, so you lordship keep it to next week so that
Next week.
My lord, I have a small approach. My lord, the time and again they are taking time. Your lordship,
So why you did not serve them well ahead? Why you serve them
yesterday it was filed and
you
copy
could have
was
served him at least a week before so that they will take an instruction.
we had let some amount be released.
Yesterday it was taken. So what?
4-5 days. Even if your lordship had directed them to file.
May we gave them the objection, reply to the IA.
Come in the next week.
Yes.
So that.
37.
My lord, after 27, when the dead people so I'm coming from Delhi all the time.
47.
So 20.
I am on mission.
2nd July.
2nd April.
2nd July.
My lord.
Item 37.
Permitted to withdraw the request. I filed a memo. In the meantime, the order blacklisting the pits of form that has been revoked. I may permitted to.
Yes, other side.
We are for the opposite parties.
No objection.
37 it is Indian Railways.
We are for the opposite party.
So no objection. Do you have any objection for withdrawal?
No one.
Memo with flag beam. Memo is there.
Only my lord may
Memo.
indicate that blacklisting period has been revoked.
No.
Item 38.
That was the delay in reference to previous for 1 day. The requests were filed with us. So there was a 1 day delay of filing of the request.
It was issued by the opposite party no file. It's an MCL.
What?
The lordship's last order minutes.
Yes. So there is a delay. What is this? There is already an order.
There's an order, your lordship should notice that the order was uploaded on 1st of May. So the requisites was filed on 5th of May. So
Out of time.
so 1 day delay was this.
So that you are accepting. Yes. The delay in putting the requisites is condoned. The office is directed to accept the requisites and effect the service as directed
Right.
by this court on 30th April 2022. Returnable.
Short
9 July. Item 39.
The lordships had also posted query with respect to the inclusion of interest.
I have seen my order. I've seen that. That's why.
Item 39.
There is a delay of
Service.
99 days delay.
No,
They have
no,
appeared
sir.
to, yes, they have appeared to caveat
I'm not telling caveat
and served office.
How many days?
99 days.
99 days. For your benefit, no difficult.
No, as your lordship. As your lordship. As your lordship.
No, if you want to file, there's no difficulty. You want.
No.
Are you understanding what?
Yes, ma'am.
This,
My lord. As your lordship.
Which one is, give him a copy. What are you doing?
IA 1865 of 2025 at flag A, my lords.
Last 8 years, in the
Last 8 years he is knocking the door, my lord, for a Hindi teacher. Last 8 years he is in the court, my client. Last 8 years. Now my government has filed the office.
What Hindi teacher?
Yes, my lord. I succeeded.
As applicant for the post of contractual Hindi teacher, he doesn't fulfill the minimum requisite
I will authorize your lordship.
mark.
Why?
Because he did not secure less than more than 50% marks in graduation, which is a mandatory requirement under the rules as well as the advertisement.
In what subject?
In the subject in graduation, right?
Total.
In aggregate.
In aggregate.
In
That's why he's a Hindi teacher, so Hindi he must get more marks.
So Hindi that the requirement was graduation with other qualifications.
Yes.
Percent marks in graduation.
Yes. And the main matter to be listed?
Fresh admission. Fresh admission. Main matter on fresh admission. Next.
I'll serve copy money. By tomorrow. By tomorrow I'll serve.
2nd July.
2nd July, my lord. 7th.
2nd July. 7th.
7th. Yes, my lord.
For item 40.
I am in VC, my lord. Matter relates to Sishu Bhavan. And on the last occasion on 16/4/2025, the lordship indicated that tender will be floated by 25th of April 2025 and it will be completed by 15th May of 2025 and the factual work started from 1st June 2025. The CMC Commissioner apprised before this court what is the development and the order passed by this honorable court on 16/4/2025, my lord.
But I really could not follow what you say.
But on last occasion, you are also observing your order sheet, order number 55, my lord. Kindly see. The matter relates to Sishu Bhavan. In para 2.1, lordship, kindly see. Order number 55, dated 16/4/2025, my lord.
Yes, so tender was floated on 25th of
Yes, my lord.
April.
CMC Commissioner will apprise this honorable court. What is the development of order passed on 16/4/2025?
That is what I wanted because
Yes, ma'am.
he told the court that the tender would be floated on 25th of April and will be finalized by 15th May.
My lord.
Time for the municipality.
What, have you floated?
My lord, it was floated, my lord. There was a slight delay because technical sanction could not be obtained. So it has been floated on 16/6 yesterday. It has been floated on 16/6. The last bid last date is 18/7. I have the tender with me. That's the notice. Because the government, the formalities may not be completed by 18/8 and we will start work from 9. That is now the device. In the meantime, I know because there is no drainage and we are constructing the drainage, we have installed a high power pump there, 24 HP, so that if there is any difficulty due to the rains, the water can be pumped out from there as the work will go.
May I pray, well? I am appearing for the Maitri sir. In this case, I would draw your lordship's kind attention to order dated 16th April 2025, my lord. Order number 55.
16th April. We are looking at it.
My lord, relevant para of the said order is at para 3, my lord.
Yes.
I will be permitted to place para 3 at base 3, my lord, of the said order. I would like to place that para, my lord. Let this matter be listed on 18th June 2025 when the council appearing for the corporation shall inform the progress that have been made as indicated in the factual report. Thereafter, I want to draw your lordship kind attention to para 2.1 measure at page 2 measure, wherein this, when the matter is taken up and the cut-off date has been given when the tender will be floated and when the work will start. The work is supposed to be started on
This is what he says, that his technical sanction, which he expected, was not accorded to him. It was accorded at a later point of time. Immediately after receiving the technical sanction, he has already floated the tender yesterday, and then 16 day before yesterday, and then has fixed the date for submission of the tender. And he says that I will finalize everything and will start the work. And in the meantime, since the rains have come, so just to have the smooth functioning for the time being, because there is no construction of a drain, and then the flow of the water may have been, I think, intercepted somewhere. They have installed the high power pump so that they will drain. There will not be any accumulation, so that there will not be any difficulty during these rainy seasons. So this is what they have said. So let them start at least the ball has rolled because of your intervention now.
Only my lord's interference of this matter.
It has rolled, otherwise it was stuck up.
For 15 years, the petitioner is waiting for justice.
Many landmarks. Protected. For your intervention, Cuttack City has developed.
No.
Many
Small flat.
transformation to Banijapur Bhavan, then Lam Sisu Bhavan, and High Court.
Badam Badi, everything. Yes, look at it, my brother has acknowledged your contribution to the city.
Will my lord's interference.
Well, I have a small submission. My lord, this is a coordinate bench, my lord, is hearing all matters related to Cuttack City. That bench usually sits tomorrow at 2 p.m. That's Thursday to Thursday. This matter is also there before the coordinate bench. In another 2140, the same issue cropped up, my lord. This is a separate. In 2140, my lord, the PL that the bench is now listening to honorable, my lord. This matter is already in session. I have also filed an affidavit there for this.
No, any matter relating to this particular this issue, Bhavan, since we are already insisting of the matter, we'll take care of that over. We are not concerned with the other.
Yes.
So you just point out to that page that this matter is already there. This is the first prior matter.
Then, my lords, what I will plead before the bench is to transfer that here so that my lords can.
We'll see to it.
Right. I would like to make this functional commission with your lordship permits. If cause of action arises, issues still surveys. I would like to place 3 important press clipping of the news item in the month of May. What happened in this issue or matter? How the beneficiaries are facing a lot of difficulty in inconvenience.
What we are concerned because that building has come up. But it cannot be made functional, if we correctly remember, because the drainage system has not been done. Only the ground floor has been utilized. We wanted the full utilization of the entire structure. For that, previously the government was shocking the responsibility in one way or other. Now the municipal corporation has come up and taken up the responsibility that we will take care of all such drainage, the construction. So let them, now they have taken. So they cannot shy away from their responsibility.
My lord,
we'll take care.
My lord, your lord has rightly pointed out and has also directed them to do, and they will also do it.
Yes, they have to.
But the minimum facilities which is required is not being provided. Even
we will consider first, let us see, because this is very important. There is an accumulation of the water during the rainy seasons, and there are foul waters also being accumulated there. Look at hygiene. We have to take care of the hygiene also in the hospital. So that's why we are taking care of. Don't worry. Yes. By an order dated 16/4/2025, the commissioner of the Cuttack Municipal Corporation was directed to disclose the progress having made with regard to the floating of the tenders and its finalized. By the said order,
the tender was supposed to be floated by 25th of April 2025 in anticipation of the technical sanction to be granted on an expeditious in the expeditious manner, and the finalization was on or before 17th of July or 16th. Before 17th of July or 16th.
Last date is 18th. It will be final. Last date is 18th. It will be finalized by 18th August.
It's to be finalized by 18th of August 2025. So it is submitted that the time so consumed the time so consumed is unavoidable because of the procedural but it is assured that immediately after the finalization of the tender, the work would commence on and from the first day of the month of September 2025. Since the monsoon season is at the doorstep, there is every possibility of the accumulation of the water, and if the same first off, water if not drained may cause the hygiene issues which cannot be overlooked, more particularly in the hospital concerning the treatment of the children. Stop. The Council for the Corporation fairly submits that the corporation have deploy which one? 25?
Installed 24 HP high power Volvo pump.
Achha?
Installed 24 HP high power Volvo pump.
Achha. The corporation has already installed.
Well,
has already installed 24
HP.
So 24 horsepower HP high power Volvo pump to drain out the waters in order to avoid any accumulation thereat.
We also have a 10 HP pump in contingency, if that is not.
Stop. It is further submitted that in case of any exigencies, that is the fault having detected in operating the said pump, the corporation has also installed the spare pump in order to streamline the smooth drainage of the water likely to be accumulated during the rainy seasons. Since the construction of the drainage of primary importance, as the building which has already been completed could not be made functional, we therefore direct the corporation to expedite the matter. So far as the other issues are concerned, it is open to the appearing the parties to mention the matter if the occasion so arise. List the matter in the month of September, first week of September.
3rd September.
What is it?
Oblige, madam. May I pray for fix a date, madam?
We have already fixed a date in the month of
Oblige.
First
3rd September.
3rd September.
Oblige, madam.
Item number 41.
Oblige.
With the case, The petition was challenging the rescission of contract, my lord, and imposition of penalty, my lord. Where, my lord, at the time of hearing, the petitioner submitted an affidavit that will complete within a period of 6 months. On the basis of affidavit, this honorable court disposed of the writ petition. Otherwise, they will take action, my lord. Against that order, state preferred SLP, my lord. And the Honorable Supreme Court remanded the matter that the order was set aside, that the original order was not, still termination is order is there, and the Honorable Court has granted go beyond of the prayer, so remitted the matter. Now the question is why the imposition of penalty. They filed a counter, I want to file short rejoinder. Because the informed order is itself.
How much time you want require?
Your Lordship.
How much time you
Your
require?
Lordship, 10 days.
10 days. 10 days rejoins. But
I love you.
matter
Mr. Palit is leading us in this matter with senior advocate, so he requested for me.
who?
Senior advocate, Mr. Palit.
Civil Palit.
Team order.
Civil Palit.
But order number 3 is operating. So what I pray my lord, let the matter be taken up on Monday or Tuesday. Lord and Senior Council also agreed to that. Monday or Tuesday. Tuesday. Tuesday.
Tuesday.
Tuesday.
Mr. Patil.
At the request of Mr. Patil.
Interim order, if there be any, shall operate till the.
Interim order.
There's no interim order. Order number 3, what had happened by they had put an interim application or not to take any, not to execute the supply order, but had appeared and said that that time the election was going on. So I said there is no urgency in the matter. So no action is likely to be taken on the basis of that.
Interim order was never extended.
Order number 3. Order number 3, but which of that it was the corporation has not taken any action.
How is that?
Not Tuesday.
Item 43.
Please go. The issue with this consideration of blacklist, the guideline provides if the contractor or not and non-adherence to the quality of the work, then it will be blacklisted. Admittedly, in the case the contract was terminated and so cause notice was issued for not achieving of the milestone, but not adhering to the quality work they have never seen. And the improved order passed on the under class PWD contractor registration rules, appendix 34, that the on the ground of that not achieving the milestone. But the guidelines, so your lordships, this guideline provides that I annexed 7 I want to this guideline to so this is the only consideration regarding my ground number 1. Lordship kindly annexes 21 lordships.
PWD.
Lordship. Lordship, page 166, Lordship. This is appendix 35. 34, Lordship. Total provision for blacklisting the contractors, Your Lordship. The chief engineer of the department may blacklist a contractor. I have, as per the SOCA's notes and demand, I have violated one, not second conditions. So, in absence of second condition, I am not qualified to be blacklisted.
Both the conditions, 12 condition has.
Condition, yes, Your Lordship. Your Lordship can leave the SOCA's notice, Your Lordship. Next year. One impung order annexed SOCA's. Lordship, annexure 11, Your Lordship, SOCA's notice. Case 126, Your Lordship. Your Lordship. Your Lordship, subject, Your Lordship. Notice to SOCA's of blacklisting Binodin infrastructure superclass contractor in pursuant to Codal Provision Appendix 34 OPWD Code Volume 2 C. Constant non-achievement of milestone on an imaginary grounds. There's only one part as they have SOCA's. I replied that matter is sub judice. I execute the work and the impugned order, Your Lordship, kindly annexure 1. Page 23, Your Lordship. They have only one ground they have held. They pass an order. The condition pro guideline and tender condition provides if there is a violation of the non-achievement of achievement milestone and non-adherence quality, then I will qualify for blacklisting. Lots of case 23.
What is the canon of interpretation of the statutory provisions? The end is always to be regarded as conjunctive, or it can be interpreted disjunctive as well.
This is conjunctive. Because you lots of 20%.
Because you know, sometimes the shall has to be read as may and the may to be shall. So it all depends upon the nature.
Exactly.
If the intention and the real object is something else, even if they have used the word and, it does not make the twin conditions to be mandatory.
I am saying because the non-achieving a milestone is a termination of contract, which they have already recovered. Same cause of action, because why I am saying it and cannot be or because the first part violation, there is a condition in the tender notice or contract that I will liable for penalty. And if the second condition, if the second condition, because the blacklisting your lordships is a severe civil consequence, I cannot participate in tender. And so this my humble summation in this case.
Where is the provision that for this non-achievement of the milestone, the penalty is?
Yes. That is similar. Lordship, my contract your lordships start annexure 2 year lordships. The relevant clause. Your lordship can have please
You have a legible type copy.
Your lordship, then lordship case 45. To resign the contract and 20%
such date as who executive, it does not mean any.
Some jerk in the Xerox.
Which you have filed.
Next page, you lordship found 20% penalty. Case 45.
One or two sentences have been squeezed in.
Yes, I think there has been some folds. 2-3 sentences have gone.
To resign the contract and 20% penalty. That case relevant, case 45. I also to resign the contract, which rescission notice writing the contractor of the hand execution shall conclusive evidence 20% of the leftover work will be realized from the contractor. And you'll also, that is also part, that is page 93, also same document. This continuing compensation for this.
So the blacklisting has a different connotations. If there appears to be a default, they can definitely take a decision of blacklisting you from participating. You are trying to make a case that since there was already a penalty which has already been imposed under the contract, there cannot be a double, the punishment.
My first round, the guideline.
And therefore, it has to be read as disjunctive.
Conjunctive, because number one, the provides that number one ground that provides two conditions. First, I have to non-adherence of quality, which is basic because we are blacklisting to putting a default contractor to prevent to participate in bidding. Number two, there is a procedure of inquiry, the same guideline. This is the substance argument. First part, that there must be two violation of two conditions. Then I will qualify of blacklist. If I will qualify, then there is a must be inquiry. Here is the inquiry has also not been done. That guideline.
Where is an inquiry?
That is clause the same guideline.
Page?
Page 1, annexure 21, page 166.
Yes.
The next, this is the constant non-achieving milestone and so and so. Next paragraph. Kindly come to 167. Next page only. The divisional officer shall report to the chief engineer if in his opinion any of the above wrong has been committed by the contractor on receipt of
So show cause was issued upon you.
yes, Your Lordship.
Focus on issue, they have not given.
Yes, show cause issued. I have not given a reply.
So
Milord, why the matter termination is pending before the High Court? I only say the adjournment of the
Matter relating to construction of a bridge, he did not stick to the time schedule. We issued show cause, he did not reply to our show cause.
No, Milord.
So, department is no alternative than to rescind the contract.
So the provided there is a
Please-
new inquiry. Where is the inquiry? Your Lordship finally the impung order. It is only say
show cause
did not
has been issued. Let
satisfactory.
him file show cause. That is we consider.
And Your Lordship, the recent judgment
No.
just said that mere termination of breach of contract not amongst the blacklisting. Recently, my Lord, because
no, but I understand the mere termination because blacklisting has to be considered in a different perspective. I understand because it really impinges upon some of the fundamental rights which is guaranteed to you.
Yes, sir.
Right to trade,
Right.
right to profession,
Yes.
because your right to trade is arrested to some extent because you cannot participate in a public tender contract. So that's why the court says that mere termination of a contract does not invite the blacklisting. Blacklisting has a serious consequences. But if there is already a condition which is imposed, and if the show cause notice was issued upon you, to show cause, due inquiry is an internal matter. That is the precondition for issuance of the show cause. If the show cause is issued, then in that event you have to appear, give a reply, or ask for a time to give me all the documents which forms the basis of that.
Annexure, as per Annexure 11, show cause notice, there is an inquiry. They have filed, you just give a reply.
No, it does not require because this page 167 says that the divisional officers shall report to the chief engineer that you have committed a default,
Yes.
contractor.
Yes, sir.
On receipt of such report means it has to be communicated to him.
Yes, Your Lord.
Then the divisional engineer officer, the chief engineer, will make a due inquiry. That's an internal mechanism. And if considered necessary, issue a show cause. He may not issue a show cause if he does not consider it necessary. Once he issues a show cause,
Yes,
that
sir.
means
Yes, sir.
impliedly there was a due inquiry made by him.
Yes, Your Lord. But in show cause,
You could have appeared and say that if you have made a due inquiry, give me a document. What is the... You did not participate, did not ask for
reply.
it.
Your Lordship, Annexure 1, they have, Your Lordship is impugn order, Annexure 123. They say it is not satisfactory. Your Lordship, that these principles, Your Lordship, they say,
That is the reply means you have not asked for anything.
is it blacklisting is to do something like to prevent
There are series of judgments
Yes,
of the
yes,
Supreme
yes.
Court on a blacklisting.
the fair opportunity.
This is what a fair, you did not avail the fair opportunity.
My reply was, Milord, that in respect of rescission contract, Milord, my case annexure.
This order itself speaks that even after several notices and persuasions, they have persuaded you also.
So that relate to termination, Milord. That relate to termination.
Constant failed to achieve the desired
No,
milestone
the milestone.
as per agreement and did not complete the above works within the time stipulation. That is that. Thereafter,
So,
If you waive your right, if you do not really go and contest, then what more?
no, Milord, at that time, there is a read pending regarding termination, annexure 13.
So that is a different issue.
Exactly.
Suppose the contract is not terminated.
Yes.
Can they not go and blacklist you for some other reasons?
Yes, other reasons. They can other. But here is a case, Milord.
So how it is correlated with the termination?
Milord, because of the termination,
That is one of the case, but it is not really dependent. Termination within the folds of the law, whether the termination can be said to be reasonable. But so far as the ground of blacklisting is concerned, they have to decide independently, irrespective of that the contract is terminated. You are citing a grounds that on those grounds only the blacklisting can be done. It is not related to termination.
Yes, Your Lordship.
It's not related to termination.
My humble submission, this regarding the blacklisting under 31C, this honorable court, my lord, identical matter, my lord. Your lordships of
Says that twin conditions are mandatory.
twin conditions they have.
Tell me whether the twin conditions are mandatory.
This my lord, I have no. Your lordships issue notice about the same matter and say that the protection regarding same clause, my lord, one copy per permitted. Can your lords same issue, my lord. Because these two are in violation of two conditions, my lord. And last time, sorry, I go for reference. Page 2 of the order. Paragraph 4 of the order, your lordship. So, the paragraph 3, the quoted of the code, your lordship. Paragraph 4, the so-called notice is only on the ground of concern achievement milestone. Yeah.
You appeared.
My lord.
So Devashish Tripathi appeared.
Appeared in that case. My brother, so far this case is concerned, we also gave him time to complete the work. Despite that, he did do it.
You are correct.
No.
The question which he is raising is not that an adequate opportunity is not given. He is raising a question that the blacklisting can only be done if the conditions enshrined in clause C is totally satisfied. This clause C, according to him, contains two conditions, twin conditions. One is the non-achievement, constant non-achievement of the milestone, and second thing is non-maintenance of the quality. He says that you have not said about the quality, nor you have not issued a show cause notice on quality, only on apart conditions of clause C. This the coordinate bench has said that once it is the twin conditions, that both must exist. Mere existence of one will not invite the invocation. That is what we have to test it. We have to test it. This is the interim order.
So
But the delay is the only condition for the decision of the contract.
Administered for 6 years.
The tender
6 years.
Sir, let me give him copy of that order of judgment. I'll see to let it
No,
go.
no, this is an interim order.
Take it.
This is given. Identical point.
Yes, please.
The learned judge has quoted the show cause and also quoted clause C.
Promoters with this OPWD code.
Yes.
Where is it is restricted to some years.
Yes, 3
That
years.
you cannot go.
No, it is
This court has.
yes, similar 3 years to maximum 10 years. Cumulative period. So they have a termination to work. They have 6 years. So that is one of the ground. But this court at your lordship.
Let it come next week, my lord.
6th May, your lordship's order is 6th May 2020. In this case, your lordship is to that also clarify that is your lordship kindly the last order of this matter.
What?
May I permit to place your lordship?
No, we simply recorded what transpires in course of a hearing. We have not decided finally.
Is your lordship observe that more particular with regard to interpretation of clause AC of OPWD code put up this matter 18th June 2020.
That is what we wanted.
On which
And
date?
we are again stuck to a basic question. You have to answer. You have to answer.
Let it come next week, my lord.
The only point involved is that you cannot say that this code does not apply. You cannot say it applies. Only point is that what interpretation should be given to clause C. Is it a conjunctive or disjunctive? You have to ask. That's the only point. If he succeeds that it is conjunctive, you are out of court. If you succeed convincing us that it is disjunctive, then he is out of court.
Let it come next week.
I keep some interpretation because
What interpretation? Already blacklisted for a pretty long time.
No, what I'm saying that the
Now,
difficulty
if we live, what we think of that? That is not to insist for blacklisting.
the operation of blacklisting.
Next week.
Don't
Don't ask any interim order which is.
highly oppressed.
Item 44.
Because of suppression of tax laws, because only they are contesting with us and they determined not to release my bill's lordship, they have done this lordship. Because this lordship kindly state and lordship kindly come to my regender. I have just annexed one document. They should reply lordship kindly come to annex 16. That is to my regender. Internal page 7 lordship of that. Internal page 5 lordship. Lordship, get it, lordship. It is lordship closure proposal. Lordship. It is a lordship 5 of my regender, annex 16. Regender. Yes, yes.
The notice comes to council.
Yeah.
Lordship, it is a closure proposal by themselves, lordship. It is a closure proposal. That is date lordship 4/7/24. The date is very important, lordship. 2/7/2024. And they have given the reasons, lordship. Next page, lordship, page 6. Clause 5. They have given their own reasons, lordship. Lordship, got it, lordship, page 6. Page 6, clause 5, lordship. Specific ground for closure of the contract. May I read, lordship? Due to change of both sides of alignment by the villagers, Khandabarini and Solada, and revised estimate is required as per revised alignment. A large number of tree cutting is required in the revised alignment, and the permission for the same is outed. Also, the voxel curve of span arrangement 4x6 m and 3 m as proposed in place of existing nala in the sanctioned estimate of this original alignment is not feasible as per the revised alignment since water spread is more at the revised alignment. Then let's come to next page. The recommendation itself at page 7, clause 9. Recommended for closure of agreement without payment of due to change of both sides of alignment by the village Khandabari and Saloda, and revised estimate is required as per the revised alignment. A large number of tree cutting is required in the revised alignment and permission for the same is outed. Also, the voxel.
So anyhow, so they can stop the work without imposing any penalty.
Grateful, lordship. But also, can look at their counter. They are contesting, lordship, without disclosing this document. That is their own document. They are saying, no, we will punish you
because you did not complete the work. Because of their fault, Lordship.
He did not start work.
I started.
There are certain trees and all that. We said that to the site where trees are there, you don't have construction there. You site where there is clearance already, there is no tree and all that. That way stated in the para 5 of our countermand. Despite that, he did not do it.
Please tell me, what was the contract? First, what was the contract? Contract to construct the road from Kandhabareni
Chandabareli side.
to Chandravali,
Yes.
Chandravel, in the district of Angul, entire state. You abandoned the construction of this stretch. Can you restrict the contract to a particular?
We are not restricting contract to a particular portion. We said that over the portion where there is clearance, you have the construction. Despite that, he did not have construction.
He has taken a contract for whole.
For the whole, he has to do it. But so far the area where the clearance is available,
You have already abandoned it.
So far,
You say the recommended for closure. Agreement should be closed.
he
Do not want to go.
did not comply to our direction, my lord. As per the contract, he has to do the portion over there is clearance. He have to start work over that portion also. He did not do it.
Then I give you a hypothetical example. You have been given a contract to construct the entire High Court building. Later on, it was found that it is not feasible to construct 7-story building. You are directed to construct a shed at the bottom. Will you do that? Tell. Because you have taken a contract, such a huge contract. Will you do only a shed there? Because he has to deploy many things for the purpose of the construction of a road, which is not feasible because whenever he worked out particular, the estimate which he wanted to offer, he has taken into account the entire stretch.
For over a 4-kilometer area, there was a clearance. You could have started work there.
Otherwise, because you have given for a longer.
No doubt, my lord.
Yourself says, no, it is not feasible because it requires trees. So you do not. Tree cutting is required in the revised allotment and the permission for the same is awaited. Also, the box sales covered of the span arrangement such and such as proposed. So this is what you say, and the recommendation was the recommended for the closure of the agreement without penalty due to change of both sides alignment and a large number of tree cutting is required. And on the basis of this recommendation, you have accepted and closed the contract, which is at page 105.
In counter, they have suppressed lordship. Though it counter after 8 months lordship, they are suppressed in the counter. This officer and my friend is going on only by their contents of the officer lordship for the ES content. By suppressing all those things, lordship is given the counter. No, he should be punished and we have rightly initial proceeding against him.
So this is what we have to take into account.
You know, that part of the nine weeks.
Where
You have given up to 9 to 1.
one.
Yeah.
So 14 lakhs are in.
Lordship.
They have blocked my 70 lakhs at least since last 3 years.
What you have done, sir? These documents are your documents.
That's not.
This was the proposal. Has it been accepted?
Lordship, they will answer lordship because lordship I don't have knowledge because they have blocked my entire lordship.
Whether this was recommendation, has it been accepted?
Last query perhaps last orders lordship directed to obtain instruction. What steps you have
Let me
taken?
take instruction.
Last order was lordship. Before vacation, this order.
Back to the you should have taken the instructions. Well, he's referring to those.
2.5 what is listed, my lord. Thereafter,
2.5 there. The order there on 2.5. So it is directed to obtain people of that regarding
On answer 16, you are.
lordship refer to
16. Because they have given it in referendum.
lordship.
Such council shall make a submission on the recommendation made for closure or rescission of contract without it proceeding.
What?
Well, a copy of order 2525 was sent to the department for instruction, but no instruction has come so far, man. Mr. Tripathi is dealing this matter.
So let the department submit what you can do. You have discharged your duty.
Yes, my discharge is due.
You have
take the
already
file,
discharged your duty. Now the department is there so reluctant, then what you can do?
Let it come on Monday. Check up.
They are accounted with the personal affairs and review lordship. Therefore, affairs immediately they would do lordship. It is not every matter lordship there.
Whatever there in the counter with reference to that, we have to only submit, my lord. Just take care.
45th one. Next word. Sure. Next week.
My lord,
Lordship,
20.
the positive observation lordship, if they will not.
In order to comply, how come? In order to comply, proof have to give.
One position now in custody lordship. We done business things.
Answer 16, let him take instruction on chances.
That's
We are challenged 14.
that's intimate, 14 minutes, intimate.
It is not 45.
I will serve the amended copy.
Yes, lordship. Without serving copy, it cannot be lordship.
No.
Next time.
Next matter.
Sorry,
Yes,
excuse
sir.
me. Lordship is already so.
You have find your counter.
The year.
There was a direction for finding the counter to the amended.
Yes, yes.
Have you find a counter, sir?
Counter will find.
Amended reading has not find a counter.
No.
Why, sir? There was a direction.
Counter will find.
So you do not like to find for the counter.
Counter will file, my lord.
Sir, come to the order dated 24th April, 22nd April.
7125 will file the counter. 7125.
Please, after amendment, you come. Do you have the copy of the order dated 22nd April? The second portion. First is the amendment was allowed, consolidated writ petition to be filed. Then it later on.
Sign
8.
counter to consider requisition shall be filed within the period 2 weeks from the date of submission of the photo this matter to 18. Has it not been filed, my lord?
Asking you were saying already filed. That was in the respect of unamended. Right?
Other
After amendment.
So.
it is from next week.
The urgency because here is blacklisting without even a single soap.
That's true. That's why we have read it.
Next week we will file a counter.
Well, next week, well, thank you.
It is 46.
May I I am for the petition of minor, last official not please to issue notice to opposite party number 6 minor. Notice was issued minor and postal tracking report shows that already notice has been delivered.
When,
And
when it is delivered?
on the address email.
When?
Minor
Ten.
notice.
Yes. 10/5.
10/5/25.
Yes.
No one has.
Yes, so what you say, madam?
Yes.
Opposite party number.
Number 6. 6, ma'am. Six. 3rd July.
Interim order may be continued. Okay.
47.
This matter, the petitioner has challenged the non-allotment of the work in his favor, though he has quoted the lowest price matter. And in the matter, the counter affidavit has been filed by the state matter.
So there is an intervention application.
Yes, madam. I am
Allowed or not allowed?
But intervention has not been allowed. That was filed last date, the court has taken note of that. The clerkship will see the last order. That
No, I've
is-
seen that, no, I am asking.
That's right, no, it is.
Have you filed?
I have filed it, it's there on the
So
call.
where is the intervention?
That is IA 7702 of 2025.
Who are you?
But in fact, as per the counter para 14, I am the acceptable bidder. My bid is acceptable, that's what state has taken a clear.
Acceptable or accepted?
Acceptable, because of the interim order, it is not yet finalized. And interim order is, it's a tender regarding transportation of midday meal rice, PM portion rice. Now, since April, this has been stayed. So I am only to say that this matter will be taken up.
Your application has to be disposed of.
Right.
Is intervener allowed?
Yes.
He is a petitioner.
Yes,
He is a dominus litis.
Yes.
He is,
and because in the counter
And
affidavit, they have stated that
Mr. Biswal is more dominus.
I am filing my rejoinder affidavit, if the lordship.
dominus is good, litis is very positive.
That's why I
What-
said dominus.
What my brother will say, I have to accept it. I have no son or.
This is by the
Opposite for no 2 months.
by the opposite party number 2.
On 12,
For transportation of the food grains / rice of Pradhan Mantri portion. This bracket, PM portion means
Pradhan Mantri portion.
within bracket India,
midday meal.
midday meal in respect of for in not in respect for district for job. Now, according to the petitioner, he has quoted the lowest price, yet his offer has not been accepted by the authority. The intervener contends that he has quoted the lowest price.
No, lowest, highest price.
Acceptable price.
Or since he has quoted the lowest price, it says.
No, highest price, madam. 98. I have quoted 69, he has quoted 98.
Okay.
Lord, your lordship is suggest.
What I said? The content that he has quoted the price
acceptable by the tender company. Right, which is reasonable
Acceptable.
and the authority cannot refuse to accept the same. To stop. The core issue involved in the instant rectification is whether the claim of the petitioner is sustainable on the basis of a pleadings so made. And in the event the same is decided in affirmative manner, it would cause greater prejudice to the intervener and therefore makes renders the intervener as a proper and necessary party. Accordingly, the application, what is this, IA? 7702 of 2025 is hereby allowed. The intervener is directed to be pleaded as a party respondent in the same in the said rectification. The petitioner of the writ petitioner is directed to serve the copy of the writ petition upon the added respondent in course of the day. In course of this day. List the matter day after tomorrow.
Yes, madam. I am filing my rejoinder affidavit today also.
Filing agenda, I'll also go through it.
And I will file the first. Tomorrow.
Monday.
Interim order will be contacted.
Yes, with the next day. Yes,
I will file my rejoinder here.
Six. Item 48.
Item 48, Your Lordship, I am appearing on behalf of opposite party number 7, seeking 2 weeks' time to file the counter, Your Lordship.
But they can't attend, Lordship. Lordship, I have simply challenged the competency of the order. Lordship, my
what you have simply challenged the
Lordship, competency of the Lordship, the sub-collector, who is Lordship, by changing of law, now Lordship, the appellate authority is the deputy determines. The entire law has been changed. Lordship, lease of 2021, action notice. At the relevant time, he was the appellate authority. Lordship, the competent authority has already disposed of the entire action process, completed the action process. Now the Lordship, who is the no more in Lordship, the sub-collector, who is Lordship, neither the competent authority nor the appellate authority. Now the deputy mind says by change of law, the deputy determines the appellate authority. The sub-collector is using the power. He is giving continuous notice to me for appearance before him, and he has filed a counter justifying his stand, Lordship, that he can do. So, Lordship, by changing of law, how can
the competent authority and deputy director minds to the competent authority?
But here this authority can assume jurisdiction.
Lordship,
That cannot be, man.
Yes, you are representing
Opposite party number 7, Your Lordship, I am the second highest.
on his application, Lordship, this supply doing this mistake, Lordship. Because he is the one of the
we will stay that particular. That changes you did that amendments which are.
Lordship, I mean, Lordship, that is the new law, Lordship, is come, Lordship.
We assume the power and go on filing the petition, but we will say that
Lordship, I have put it, Lordship, everything else.
page.
Lordship, in the cover page, it is not, I end, Lordship, it is 27, Lordship, I have also given the.
What is the rule?
Lordship, Annex 5, Lordship, kindly see there. The same notification I have given, Lordship. On 27,
Well, You are relying on rule 27.
Rule 27, Lordship.
Oh, this is what is the amendment.
Amendment, Lordship.
27 December 2022.
Two.
Yeah. Oh, he has given this. Who is now the appellate authority?
Now the deputy director minds, Lordship. Now the competent authority do. Now the mining officer is incompetent authority. He can exercise all powers, Lordship. The role of appellate has not come. An aggrieved party can approach before the appellate authority if time comes, Lordship.
Now the original identity of the
Lordship.
competent authority mining officer, deputy director means the appellate authority.
Appellate authority. Competent authority is the mining
Mining
officer.
officer.
Now mining officer can do, Lordship.
Instead of Tahsildar.
Rule 27, Lordship.
Yes, where is the threat that he is calling you every day?
Lordship, I have annexer Lordship, that is state and Lordship come to last annexer. Annexer 10 Lordship series.
Election,
10 series page 68 Lordship.
which one is the latest one?
Latest Lordship, that is 16/11/2024 Lordship.
So thereafter he is gone.
He's sitting over the matter Lordship. He has brought the entire records to before him Lordship, and he's sitting over the matter. He's not Lordship leaving this file.
He's not sparing this file.
File Lordship, he's mining officer. He's saying, no, I will deal with the matter. And if the file the counter, no, I will deal with the matter.
Stay there.
Let the competent authority, my lord, now deal the matter.
No, he is your officer, sir. What are you doing? You have brought a changes in the statute, and this officer, if he is so errant, then will you not take steps against him? That it is beyond your domain. You can't take it.
In similar matters, we have asked for others.
Lordship, many cases, Lordship, we given direction to the competent authority to deal with the matter, Lordship. Because many matters, the tahsildars are sitting over the matter. So there's a government direction to transfer all those files to the mining department, still in mind, so that they can deal with them.
What is the district?
Lordship, this is Lordship, sorry, Lordship, Mohirbhanj, Lordship, this is. Mohirbhanj.
Mohirbhanj or Balasore?
Mohirbhanj is Balasore, Lordship, Mohirbhanj. West Bengal border. Mohirbhanj is the border in between Lordship, Odisha and West Bengal border Lordship, that is Mohirbhanj. That is.
Even Balasore is also border.
Balasore, some part of the.
Balasore and Mohirbhanj
are also Lordship.
They are neighbors.
So nearly 170 kilometers.
More than 200 kilometers.
We will restrain him from taking any further action. No. File your counter affidavit, madam.
Yes, Your Lordship.
Only file it, but we will restrain you from taking any steps, including the issuance of dollars.
We should buy. And subsequent letters by the cancellation issued by after submitted after amendment made by virtue of result and concession, that is second amendment rules 2022. This subcommittee seeks to have proceed with the matter under set rules. They also said mining
official Lordship.
Proceed with under the minor mineral concession rules.
2016.
This so happens that operating partner of
7.
6 to submission to 5 in lieu of submissions made by also from the petitioner. Looking at
the amendments. Carried out in some management concession rules. You will be notified in this, is it, Odisha Budget extraordinary audited in 28/12/2022.
This is
This whole times, the same is that the subcollector, sees to have jurisdiction, possibility matter. And with that, still forward to sleep by circulate the power particular public partner response to. And what is the OP6 to procedural or reproduction? Because he's
no, we can't by any tribunal. First thing we have to say that he does not have, she wanted to file a counter. So let her come.
Let's
Please. All the names.
Item 49.
49 will receive,
Okay, check.
will receive the parawal summons. We need 2-3 days to file the counter man.
1 week time. It will come.
In this case, my lord, the issue is, my lord, though there is a notification and a guideline issued by the government to purchase the goods from the MSME sector, my lord. My lord, they are purchasing.
Purchasing from a private sector. Good.
That is the issue.
Okay. You find out accountable within a week. Matter to be listed there are.
My lord, may I pray, my lord, a short date may be fixed?
25th. Item 50.
Item 50, because of late filing of the requisites, fresh notice on respondent 21 could not be issued.
Except.
The returnable date will issue.
Is it this?
Written out at 16/7.